All right, where's Joseph Juarez? Come forward. All right, so on this case, where are we on discovery? And I know because of the sensitive matter, it's not going to be available by normal means, so.
Correct. Judge, I believe all the reports, everything on Bearpick that can be viewable by defense is there. Of course, because of the nature of the charge, there are some things we can't put up there. I'd be happy, if defense does want to come in, we have a room set up to where they can view those images to kind of check that box if need be.
Okay, all right, so has an offer been tendered?
There has not. We've talked a little bit about framework, and that's something I'm going to go ahead and start.
All
I'll
right,
get an approved
please
offer.
whisper. Yes.
Yes, I'll get an approved offer and convey that to the defense.
All right, so when will you anticipate having an approved offer?
I know my chief is busy today, but probably my hope is by the end of the week, if not then early next week.
All right, and how old are you?
23.
Yeah, just to go back to discovery briefly, there is a video that has to do with the SSM search that I know the state has it. I think they suggested it's been down, but neither one of us have looked at it yet. That's the biggest issue that we've been talking about from the beginning. Once we sort that out, then yes, we can talk about this.
All right, so when is that going to be sorted out? When will he have that to view?
I'm in trial again, so not today, soon.
All right, so where are you in trial? Okay. So what are you going to be asking for a motion to suppress or what?
At this point, that's premature, Judge. Apparently there's a consent for what is the matter, which is signed, what is told. If it's on video, did they record it? I do have the actual document. The state has provided that to you. So it's not overly complicated. I think it's just a matter of looking at the video.
All right, Norma, set this for a plea deadline date and potentially a motion to suppress the week of July 28th. July 28th?
28th. Okay.
All right, once you sign the reset form, you're excused. Thank you.
All right. Thank you, Your Honor.
Thank you. No, set it as a motion to suppress and a plea deadline date. Yes. Who is here on Jorge Sandoval? All right, Mr. Sandoval.
Good to be at your court early, Judge.
Thank you. Good morning.
Morning.
Are you all ready to proceed on the motion to revoke?
Yes, ma'am.
All right, this is Criminal Trial Division. It's a motion to revoke.
Okay, Judge.
All right, the court is calling 2023 CR 11289, State versus Jorge Sandoval. Can I have parties announce?
Jason Garahan for the state, Your Honor.
Robert Robach for Adamant. For Sandoval.
And are you Mr. Jorge Sandoval?
Yes, Judge.
Did you review the documents entitled Motion to Revoke Community Supervision and State's Motion to Supplement pending motion to revoke probation with your attorney? Did you understand it?
Yes, Judge.
Are you the same Jorge Sandoval who was placed on community supervision in 2023 CR 11289 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on January 30th, 2024 for a term of 5 years? Is that you?
Yes, Judge.
All right, state.
Yes, Your Honor. Violated condition number 1 on or about the 12th day of November 2024 in Medina County, Texas. The defendant Jorge Sandoval committed the offense of evading arrest or detention with a vehicle in violation of condition number 1.
How do you plead to that? True or not true?
True, Your Honor.
Your Honor, we'll waive the remaining violated conditions.
Any objections to the waiver?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 5 years in the prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, and it is to revoke the individual offers probation and to reform the underlying sentence to 2 years in the Texas Department of Corrections.
All right, thank you. And are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, has he done anything on probation? Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Jorge Sandoval,
All right, have you done anything on probation?
I completed the Saturday, completed the aftercare program. My UAs were clean. Reason I wasn't reporting because I was incarcerated for 6 months.
Mhm.
And I got extradited here for the MTR.
Well, I mean, that doesn't have anything to do with the evading arrest, detention in a vehicle. So at some point you were not incarcerated, you were evading the police in a vehicle. So other than going to SADF, which if the court ordered you in an inpatient treatment, you had no choice. So you're a captive audience at SADF. So other than SADF, did you do anything else?
Work.
Probation?
Judge, Mr. Sandoval completed the SATA inpatient treatment. However, the aftercare was, there was the violation of program. He did complete the intensive outpatient treatment. And out of the 100 hours of community service, he has a balance of 23 hours.
All right, so what was the issue with the aftercare with SADF?
I'll have to look in his file, more extensively, just give me one.
What was the issue with your aftercare and SADF?
Actually, with the community service, I completed all of it.
No, I'm talking about SADF. You had to go in inpatient for drug treatment. Then they have an aftercare program. So my question is, with the aftercare program, why did you not successfully complete that?
Oh, I finished it
No, the report from probation is there was an issue with aftercare.
because I got incarcerated and that's why I couldn't report no more.
Okay. And what were you incarcerated for?
For
This, the
county, yes,
evading?
yes, ma'am.
So you didn't successfully complete aftercare because you
did
picked up new
successfully.
charges. Why are you picking up new charges? I don't understand.
Actually,
Mm-hmm.
Judge, he has been in for over 245 days.
no, it's 580 days.
The violation of the new event was why he was exited from the aftercare.
All right, this is what the court is going to do. The court is going to revoke. The court is going to sentence you to 3 years in the prison, give you credit for any time served, and the court will request the therapeutic community. The therapeutic community doesn't increase the time that you're in custody, but they are there to hopefully help you become a better citizen and to help you maintain your sobriety. When you're released from prison, if for some reason you can't find a place to go that can help you maintain your sobriety, if you come back here, I'll pick up the phone, call somebody. You understand? To help you. Did you,
What do you mean, like, place of sobriety?
to help you maintain your sobriety, because obviously you still have drug issues.
Well, I'm planning on leaving the state.
Oh, okay, then. Well, somebody there will probably be able to help you. And I wish you the best wherever you, whatever state you choose to live in.
Thank you, Your Honor.
All right, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, you have a limited right to appeal. And that right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, and I'll give you credit for any successful completion of inpatient treatment. All right, is there anything else?
Nothing, Your Honor.
All right, and I don't think, we're off the record, I don't believe any of the new number ones are here in Bear County, is that correct?
No, Your Honor.
They're all Medina?
They're all-
So you'll have to see about those cases if you have not taken care of them there.
Yes, Your Honor.
All right, good luck to you, okay?
Thank you.
You're welcome.
Thank you, Judge.
Who is here on Luis Gandaria?
Present, Your Honor, we're ready on that matter.
All right, if you'll have your client come forward. Thank you for pronouncing that correctly, Laura.
You present my name, Judge. I think you're saying my name right.
I'm working on it.
Mhm.
All right, so you have a motion for a bond.
That's correct, Your Honor.
Has a bond been set or no?
He's currently remanded without bond. I did file just this morning a motion for PR bond because I did associate that with the newly indicted case.
Mhm.
And I did file this writ as a result of going over the 90 days
Mhm.
without indictment. We're currently at the 111th day.
Mhm.
And as per Odyssey Court records, the matter was indicted yesterday.
Mhm.
And I know that as per 17.151, the initial burden is on the state to make a prima facie showing that the case was indicted within the 90 days, and I don't believe that has been.
All right. Was the case indicted within the 90 days?
No.
All right. And so what are you requesting
We're
before we go on the
requesting,
record?
A PR bond, Your Honor. My client is indigent. He can't make really any.
Okay, all right. So we'll go on the record. I'm just trying to figure out
Oh, yes.
what's happening. So you requested a PR bond. The state has already said they didn't indict within 90 days. All right, court is calling 2025 CR 00. Oh, before I go on the record, have you had a chance to review the state's file
Regarding the newly filed case,
regarding, is there another case other than the unauthorized use of vehicle?
felony, no, ma'am. He has a couple of misdemeanors.
All right, have you had a chance to confer with the state on this?
Not on this judge because I did see some preliminary offense reports, but the matter just did get indicted yesterday.
What do you have in your file? Or you reviewed the state's file?
Well, the thing is, Judge, that I'm kind of pressed for time this morning. That's why I came here early to get this hearing before the court. And then I was gonna request the PR bond also because I need time to review that discovery with my client, the videos, and all the reports. And since this matter just got indicted, that really triggered me to see about going upon my client's defense, knowing that the state was finally gonna move on his case. So
Right, and you have all of the videos, correct?
I have no idea.
it just says it just got indicted yesterday, Judge. I have not been able to look into that. My efforts have been focused on the writ.
All right, does anybody know what his criminal history is?
Locally, yes.
All right, let me see.
PG 1 1 to 4, for which he was sentenced. A felon possessed firearms. Seems as though it was dismissed. Give me a moment to check on that, Judge.
Okay.
That was dismissed.
All right, so what is his NC?
Authorized use of a motor vehicle for which he was sentenced.
Does he have any out-of-state history?
Don't know, Judge.
Can you run that to see if he has out-of-state history?
I cannot. I can ask our investigator to run it.
All right, if you have the investigator run that.
Never lived in English. Your Honor, would it suffice if my client under oath testified as to his potential out of state record? He's saying he never lived out of state, has no offenses anywhere out of state.
Okay, and I'm looking on my system too, but the system is running slow. All right, the court is calling 2025 CR 006612 State versus Luis Antonio Gandaria.
Yeah.
Sorry, Junior. Could I have parties announced?
Andrew Harris Edelman for the state.
Renee Munoz on behalf of Mr. Gandaria.
And are you Mr. Gandaria?
Yes.
Right. Counsel, you've filed a motion for a bond. And off the record, both parties agreed that your client had not been indicted within the 90-day time period. So what are you asking for, counsel?
We're respectfully asking for a personal recognizance bond. My client has been in custody for the last 111 days, not able to make bond. He does not have any kind of resources in terms of having a job or employment to make bond, as well as friends and family are limited, that they will not be able to have him make a sufficiently bond if reduced. That's for the foregoing reasons why we're requesting a motion for personal recognizance bond due to and using the mechanism of the 17.15 writ that was shown to be in violation of in this instance.
All right, do you want to call your client with regards to the amount of bond he's able to make?
Yes, Your Honor.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Luis Antonio Gandaria Jr.
All right, you're gonna need to slow it down because the court reporter has to take everything down. And if you'll speak up so the court reporter can hear and so I can hear. All right, defense, you may proceed.
Thank you, Your Honor. Mr. Gandaria, are you currently in custody at the Bear County Jail?
Yes,
And how long have you been in custody there?
and I've been locked up since November 9th.
Okay, then you got out and then you've been in custody since February, is that correct?
Yes.
Okay. At this time, are you currently employed?
No.
Do you currently have any amount of savings that would allow you to make a bond, if the bond were set at a certain amount?
No.
Okay. Do you have any family or friends that would be able to assist you in making a bond that the court may set?
I don't have a dad. I only have a mom.
You only have
Okay,
one.
so you need to speak up. And
Only-
I know you're speaking
only-
towards him, but
I only have a dad. I don't have a dad. I have a mom.
Okay.
And it's on mom.
Okay, and then your mom, is she employed?
Yes, but she only come much.
Oh, so
Yeah.
she makes a little money to sustain herself and her
Yes.
household, okay. Have you lived, resided anywhere outside the state of Texas?
No,
Okay. Do you have any criminal history outside of the state of Texas?
I do not
Are you swearing that under oath today for the court?
swear I know where. Oh, I don't have any warrants or been out of Texas. Anywhere.
If you are able to make bond, would you attend all court sessions as required?
I will.
Would you follow conditions of bond if the court were to set them?
I will.
If the court required you to check in with the pretrial officer, would you check in with that office as required?
I will.
Those for the questions, Judge.
all right, any questions?
A few. I want to make sure that I understand this correctly, Mr. Gandaria. You were originally arrested on September 27th, 2024, correct?
Yes.
And you were released pending that court appearance?
Yes.
And subsequent to that, you were arrested and charged with the offenses of evading arrest and the instant offense unauthorized use of a vehicle, correct?
Yes.
So you are still pending trial for the September 27th, 2024 offense, is that correct?
Yes.
Thank you.
Just a couple follow-ups, Judge. Regarding those offenses that the prosecutor listed, have you been found guilty beyond a reasonable doubt as to any of those offenses?
No.
Okay. No further questions, Judge.
All right, I do have some questions of him, but I have some procedural questions. So with regards to the cases, the evading arrest, detention, and the burglary of the vehicle, were those cases alleged to have been committed before or after this case?
The burglary of the vehicle, as far as I'm aware,
Mhm.
occurred prior to the instant offense. The evading arrest arises out of the same criminal episode.
All right.
As far as I can determine.
All right, so then my next procedural question, with regards to the burglary of the vehicle. I'm assuming he had that case pending, then he bonded out. And then that's when he's alleged to have committed unauthorized use of a vehicle and evading arrest, detention.
Yes, Your Honor. Thank you for understanding the timeline.
All right. Now I have a question for you.
Yes.
Have you ever had any type of mental health diagnosis or been on any type of medication for mental health issues?
When I was younger, I was bipolar. So bipolar.
All right. Everyone, we're on the record. Then my other question for you is, have you ever had any type of drug use in the past?
Like growing up, yeah.
All right. And what would that be?
We,
Anything other than weed?
I met,
Everyone, we're on the record. Please stop talking to the right of me because I'm trying to concentrate on what they're saying. Yes. So other than the weed,
I messed around with meth, but not so much
how long has that been?
in years.
Years? How many years?
5.
All right. Any other questions?
Not from the state.
All right.
Nothing.
So defense, I know that you're requesting a PR bond state.
17.151 speaks of at least one of two alternatives: release on a personal bond or by reducing the amount of bail required. So it seems to me that considering Mr. Gandaria's recent criminal history, release on a personal bond does not seem wise. His current bond is set at $5,000. Considering the relative paucity of information provided by the defendant, for instance, that he has not actually brought in any other witnesses to testify to their financial circumstances to substantiate his lack of ability to make bond, the state recommends a reduction to $2,500.
Your Honor, in response to that, 17.151 does not state that a PR bond is triggered or a reduction is triggered because of, with respect to criminal history, severity of offense. The bottom line boils down issue is the state did not move on this in a timely fashion. And this has caused myself as defense counsel to now just at the 110th day have access to these things, which slows down the court, slows down the judicial process. Relative to this, the violation of 17.15 has been shown. Thus, it's triggered for the court, obviously, to determine if the PR bond is whether to be granted or not. And my client testified, believe honestly, that he can't make any kind of substantial sum to a bond. And because he's been in custody with 110 days and hasn't bonded out, also further represented by the Bexar County Public Defender's Office, has been shown to be indigent. That's why he was appointed to the Bexar County's the Public Defender's Office to begin with. That we're asking for a PR bond to be granted, so he has the chance to prepare for his defense, not in custody, and it's not any fault of his. These are just allegations. Nothing has been proven beyond a reasonable doubt, and he's been waiting patiently for the opportunity to defend himself of this charge, which has just arose in terms of a formal indictment yesterday. So for those foregoing reasons, Judge, we're respectfully requesting a PR bond that will lead to the efficiency of this case being resolved and his constitutional rights being intact due to a lack of timeliness on the state to indict his case.
May I make one further remark, Your Honor?
Yes.
It seems to me that perhaps 17.151 is not applicable in this case to begin with, because Section 2 of that article provides that the provisions of this article do not apply to a defendant who is, subsection 2, being detained pending trial with another accusation against the defendant as to which the applicable period has not yet elapsed. And that seems to be the case in cause number 2025 CC 002343, for which the defendant was taken into custody, as far as I can tell, on February 12th of 2025, and information was timely filed, and he is pending trial on that accusation.
All right, and that's why I was asking the parties, the legal process as far as the time. All right, this is what the court is going to do. The court is gonna grant the PR bond. I'm gonna set your bond at $5,000, grant a PR bond. I'll ask that the fees be waived. There's to be no driving. There's to be regular UAs, a referral to Center for Healthcare Services just based upon what he said about his previous mental health. Any other conditions state you will request?
Partial GPS tracking, Judge.
We'd oppose that, Your Honor. If he's going to be going to regularly UAs and referral for CHCS appointments, we would request as limited movement to curtail him trying to get himself into services and treatments. He has this case as well as the misdemeanor cases. He would still need to make a bond on or have a judge rule on that. And he's already agreed to make all appointments as required and show up to court as required. He's been in custody the last 3 months, so I think he can kind of do something more. And obviously there, he's not, with the understanding that he's not going to be let out because his case has already been indicted. Yep. But since just the indictment just happened yesterday, we're requesting that he be allowed leave to attend some of these appointments to get to the root cause of what may be causing him to enter the criminal justice system.
All right, and the court will note for the record that the court does not, and I've done the research, the court does not see any violent history in his past that would warrant GPS. But I do know that there is an issue with him driving vehicles that do not belong to him. And I'm basing that upon the indictment where you've been previously convicted of unauthorized use of a vehicle. So, the court's conditions will stand. Ms. Ferguson, on this case, I need a 30-day reset. And that is going to be a plea deadline date. You all will need to confer off docket.
Yes, Your Honor, we'll review that discovery in a timely fashion and we'll be here ready for court.
Can we not do it that week?
I might have some July 4th plans one week myself, Judge.
Yeah, that's why I was like, maybe people will have plans. All right, it's going to be July 10th. Ms. Ferguson, if you'll give him a reset form, thanks.
Thank you.
Thank you, Your Honor. We'll get
You're
that done.
Who is here on Israel Mankata? Yes. And let me bring him in. And I think we're just here on an update on his driver's license or something.
That's it. And as I understand from the last time he was here, he had gotten an appointment with DPS,
Yes.
hopefully.
All right, Mr. Mankata, if you can start your video, please.
Yes, Judge.
All right, so Mr. Mankata, where are you as far as your driver's license?
Okay, so the first time I went, they told me it was gonna be so June.
I'm
And,
sorry, you keep fading in and out. So you say, so look, the first time you went, what?
They said it was suspended to the third and set me an appointment 29th of last month.
Yes.
So I went. I even went to I got my traffic tickets handled, and I did my driver's courses, and then she told me there that this very last time that I went that it's suspended until June 3rd of next year, which I was unaware of. And she gave me this form of proof. I'm not sure if you
Okay.
could see it.
No, I can see it. You can hold it down.
Okay.
So he's suspended until June 3rd of next year. Probation. His license is suspended until June 3rd of next year.
Judge, what I would suggest is real simple. Keep him on probation and tell him not to drive a vehicle until he can get his license.
Because that was the issue that we had, right? He was driving, he said he needed to get to work and so forth.
Okay.
My concern with that, of course, is just the cost of applying for the occupational license, the SR 22.
So how long is he on probation for?
That's actually a good question.
Yeah. I'm trying to find his. I know he was placed on deferred.
January.
Oh, okay. So he's on till January 2026. Maybe by then he will have done things. We can. I really don't want to extend till June of next year.
Right.
So we can see where we are on January 20, you say January 2026? Let's see. All right, we'll just see where we are.
Leave it at that.
Okay.
Thank you, Judge.
Yes. Unless you have some other suggestions.
Judge, I would like to maybe look over Ms. Mokata's case a little bit closely to see if there are any other outstanding conditions that he has, and try to come up with a plan, and maybe we can speak with the state and if he's completed everything and he's in compliance, I'll see if probation officer works in as a request for early termination.
All right, so how much time do you want?
I get all of this done by the end of the week, so Monday.
All right, Ms. Ferguson, Mr. Mankata, we're gonna recall this for Monday. Mr. Mankata, you'll need to appear by Zoom on Monday, okay? That's
Okay.
June 9th.
Okay,
All right, thank you.
okay, thank you.
You're welcome.
May I be excused?
Yes. Who is here on Leroy Smith?
Morning, Judge.
Good morning. How you doing?
Good, good.
Morning, Judge Boyd.
Good morning. Thank you for dressing appropriately for court. I appreciate that.
Well,
All right, so on this case, where are we?
Judge, I've come into some new information. So
Mhm.
we're gonna ask for a reset for a discovery setting.
Okay,
And the state is gonna talk to some witnesses, I would hope. And we'll all get on the same page at that point.
all right,
so-
so what is the discovery
Uh,
that's missing or outstanding?
it's not necessarily, it's witnesses, how compliant they're gonna be
Okay,
for the state.
all right, how long is this gonna take?
Your Honor, 30 days?
That'd be fine, Judge.
All right, Ms. Ferguson, can you recall this the week of July 7th?
That's fine.
All right, we're gonna come back on July 7th. That will be the last discovery date.
Thank you, Judge.
All right, thank
Judge.
you. Yes, you're welcome.
Let's see how this item is.
Oh, and defense, remind your client not to be late for court.
I already have, Judge.
All right, thank you. Who is here on Daniel Hesbrook? All right, so,
Hi, Judge.
so on this one, you're currently in jury trial?
I am Judge, but the issue that's impending with Mr. Hesbrook is that they took his cell phone. I have a ready motion on file because we believe there's exculpatory evidence in his phone. But we can't get to it because they want to do a phone dump, so we've been patiently waiting and he can't get out on bond.
All right,
It's now been weeks and apparently the phone dump hasn't happened yet. So I think we're gonna try and coordinate where they're gonna give me access to it, so they don't have to keep waiting. I can show them the evidence I think that would help us resolve the case.
And then, Your Honor, Ray is absolutely right. What we're planning on doing is having an appointment we can set up within the next week or two. And then we can go with counsel to the phone, and then they'll have no problem getting in and collecting any potentially exculpatory evidence in real time. And it should help assuage any discovery issues we may
when
have.
is this gonna happen?
We're very anxious to do it, Judge, so if somebody's available from their office, wherever it may be, I will make myself or Victoria available the next week or two to get over there and do it.
At most, Judge, maybe 2 to 3 weeks.
Now, we tell the. After 3 months, Judge, they had the phone since he's been in custody.
All right, I can set you for June, be back in court on June 16th, so that will mean you all will have to have it done by next week.
I'll hustle, Judge.
I just think it might be potentially a little bit difficult. Of course, I'm filling in for the court, and I know that half of the team, will be doing other things. If potentially we could just have it for the week after, even if it's the Monday of the week after.
With this case.
Okay, Judge.
So it can be, let me see. At the latest, I can put it on June 17th.
Okay, Judge. We appreciate it, and we will work with counsel to get that appointment scheduled.
All right, Norma, June 17th. Now put it for jury trial. Good morning. Hello, thank you for dressing appropriately for court. Thank you. All right, court is calling 2025 CR 005411, State versus Roxanne Marie Hayes. Could I have parties announced?
Andrew Harris Sadelman for the state.
Sean Sheffield for defending, we're ready.
And are you Ms. Hayes?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I did, Joe.
Court will find that the state is in compliance with discovery. Probation, this is an application. Ms. Hayes, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, waiving count one, proceeding on count two.
No objection.
Did you review the admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
In count two, you're charged with the offense of possession of a controlled substance, penalty group 1. 1 grams to 4 grams as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
She has to sign. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Hayes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2. They're asking that your punishment be assessed at a $2,000 fine. They're recommending deferred adjudication, and they're asking for restitution to SAPD for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations? Then to the offense in count 2, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Should be contained in Exhibit 1 and attachments, Judge.
No objection, Your Honor.
State, you may be excused.
Thank you.
Did you review the document entitled waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and laboratory reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we just asked the court to follow his recommendation.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
16 and 11.
Who do they live with?
Me.
Are you employed?
Yes, ma'am.
What do you do?
Right now I'm doing Lyft, but I used to work for CPS.
I'm sorry, what?
CPS.
What is
Energy.
CPS? Oh, CPS Energy. If you're drug tested today, what are the results going to be?
Clean.
All right, when's the last time you used?
About 5 years ago.
I'm sorry, what?
5 years ago.
All right, this case is not from 5 years ago.
Your Honor, that it was not for her consumption regarding the drug.
All right, so I don't even understand. Is Child Protective Services involved?
No, yes.
I don't understand why not. So I have concerns, and these are my concerns. She has a 16-year-old and 11-year-old living with her. And according to what I'm reading in the police report, she was dealing, and the car is smelling of marijuana, and then the car has license plates that don't belong to the vehicle. It comes back as a different vehicle. Then she has this person who's with her. Who is that?
My husband.
All right, then, so you have her husband who's involved in all of this, and they have a 16-year-old and 11-year-old at their home. That's an issue.
I understand, Judge. As you can see, this is a little older case. This isn't just from a month ago or a couple months ago. I do not believe she has any priors. I believe there was a prior charge, but it was dismissed. This was a one-time thing, Judge, and she has been on the straight and narrow since then, and even prior to that, Your Honor, she has.
All right, so let me just tell you what's gonna happen. I'm gonna follow your agreement, but I'm gonna have you drug tested today. If that drug test comes back as positive, then she's going into the Bexar County Jail to be transferred for inpatient treatment.
Okay.
All right, probation. On this case, this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. I'm going to want field visits 1 time per month until further notice. Please tell probation to check on the children. There's to be regular reporting by Zoom or in person, regular random UAs. Do you have your driver's license or identification with you?
Yes.
Okay. There's going to be a $2,000 fine. That will be probated.
Thank you, Judge.
Restitution to SAPD for drug testing. There's going to be 200 hours of community service restitution. I'm going to require that she completes parenting classes. Once that's completed, the community service hours will be deemed satisfied. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. And with regards to the no employment with minors, that includes if somebody wants her to babysit, you're not allowed to babysit. There's to be a TAP evaluation out of custody, follow recommendations. And I'm going to ask for a UA today. So once probation goes over your conditions, you're going to leave directly from here and go and obtain your UA.
Okay.
Probation, is there anything else? Yes. All right, is there anything else you need from the court in order to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And I just have a question for myself. We can go off the record. So where were your children during this entire, at home alone?
No, with my parents. My parents live with me.
All right, so now I know who's raising the children.
Oh, no.
Okay. Well, I mean, you were not doing it that night.
It was one night.
But you, according to the police report, you all were smoking marijuana in the vehicle
I'm allergic
because the
to
car
marijuana.
smelled like, oh, you're allergic to marijuana, but y'all driving around with marijuana in the vehicle and the smell of marijuana. I find that very odd. I have some more luggage to unpack with her, but before I unpack that luggage, I want you to speak with probation, and then you're immediately going over to felony drug court.
Okay.
And probation, put her on the UA hotline. Everybody's allergic to marijuana, but they're always around it. All right. I guess maybe hotboxing was in the vehicle. Who knows? All right. Thank you.
Thank you.
Mhm. All right. Who is the other person you have so that you can go to? I'm sorry, who?
Daniel Berlonza.
All right. I don't have the file for Daniel Berlanga. All right. Mr. Berlanga. All right, what is happening with this case?
Your Honor, both sides are satisfied with discovery up to this point. An offer has been tendered. We have respectfully rejected, so a trial setting would be best.
All right, how long do y'all expect this trial to last?
2 to 3.
About 3 days, yeah, I would say.
All right, Ms. Ferguson, this is family violence. It's a 3-day jury trial. And they were actually scheduled for jury trial today,
Yes, ma'am.
but they're currently in trial.
That week, Ray is out that week of the 4th.
You want to do it June 16th?
Yes, please.
All right, June 16th. Thank you.
May we be excused afterward, Your Honor?
Yes, thank you for dressing appropriately for court.
Appreciate it.
All right, who is here on Eric Mitchell? All right, you're set for jury trial today.
Yes, Your Honor, this is a case we approached on last week. I told the court that I've taken a new position, and so I'm getting off all my cases. So I did file a motion to withdraw.
Okay.
I think it is the last case I have in your court, actually.
Okay.
I still think with my new position, it could be better suited with a new attorney. If you wanted me to stay on, I just need to get with Norma and find a week where I can take.
Oh, I mean, it's set for trial today. So we would start jury selection tomorrow.
Yeah, Judge, but I'm not ready.
I mean, this has been on the docket since January,
I know, Judge.
so that's where we are. All right, see y'all back tomorrow. You're welcome. All right, who is here on Claudel Carney? This is contested.
Should be around.
Okay.
Let's go from the.
Good morning.
We weren't informed until this morning that it was gonna be a true contested hearing. I made an offer at the last setting. He was gonna talk to his client and he informed us today, so we just asked for one recess. We get the witnesses in that we are needing for.
All right, what witnesses are you missing?
Well, it's 2 number 1 violations, Your Honor. We're needing the victims in both, and there are 2 separate witnesses as well that saw the number 1 violation of the assault take place. That we need to coordinate, as well as a probation officer who testifies about the violation of condition number 22.
All right, are they able to appear by Zoom?
I can see if they can. I can.
All
try
right,
to
if you can
contact.
check and see if they can appear by Zoom this afternoon.
Okay.
All right, just have a seat. We're gonna see where we are. Thank you. All right, here on Domingo Villa. All right, and is this going to be a plea?
Your Honor, it's a PSI. The plea was taken by Judge Angelini.
Oh, okay.
At that time, the state did not have an answer on the misdemeanor outcome, but that is in the PSI.
All right, the court is calling 2024 CR 012063, State versus Domingo Javier Villa. Could I have parties announce?
Andrew Harris, Animate for the state.
Eric Hernandez for the defendant, Mr. Villa.
And you're Mr. Villa?
Yes, ma'am.
All right, he entered a plea on April 21st of no contest. According to the plea bargain agreement, the state is recommending deferred adjudication. A PSI was ordered. Have both parties had a chance to review the PSI and TAP evaluation?
Yes, Judge.
We have, Your Honor.
Any objections to the PSI or TAP evaluation, state?
No.
Defense, any objections?
None.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. We've reviewed the PSI and I know that they marked that the defendant has minimized guilt. Mr. Villa, in his statement, I don't think he's minimized guilt. He did accept responsibility. He realizes that the actions he took, including leaving his property, kind of removed any self-defense he could have alleged. And that's why he accepted responsibility for this. He is expecting his first child. His girlfriend is scheduled to be induced this evening at 7 p.m. 7 p.m. That'll be his first child. They're expecting a little girl. He does have gainful employment. His employer does do random UAs, not to suggest that the court doesn't need to do their own safeguards, but that is also one of the reasons why he has not used any marijuana or THC in the past year. This offense occurred when he was just over 18. We believe this is going to be an excellent opportunity for him to take something from this, learn something going forward, and we think he'll be a good candidate for deferral.
Okay. Anything you wish to say?
No,
Are you employed?
yes, ma'am.
What do you do?
I work at the kitchen in the Windland Foods. I'm the mix prep. I mix vegetables for the mix sauces.
Oh, okay.
Yes, ma'am.
What type of vegetables? I'm
Oh,
always interested.
jalapenos, onions, and all that. Just mainly that fresh vegetables like tomatoes and all that's from someone else.
Right.
And spice kits, all the spice.
I always have an intention to do that myself instead of buying it. It never works out. So what are your plans to do for the rest of your life? I see that you completed high school. So what is your dream job? What do you want to do?
Oh, I would like to stay here and become bigger there, supervisor and all that stuff. I want to have my family, my beautiful family, and support them and be a good man for my family.
All right. And these people that you were having issues with, are you still living in the same place?
Oh, yeah.
Are you moved?
Yeah, I know. I moved away, but I mean, they still live there. Whatever, just to know that we passed like nothing.
All right. And so do you have any occasion to go over there? There's no reason to be over there?
Yeah, just to go wash clothes at my mom's house and stuff. I mean,
Oh.
nothing happened.
They live
Um,
about 3 houses away,
yeah.
his mother and the complaining witness,
All right.
and his grandparents.
Yes, ma'am. My grandparents
Okay.
next to me.
All right. So they say that you're just a child and they just want you to apologize to their mom. That's all they want.
Yes.
And they said that's all they wanted from the beginning. They don't want you to go to jail. They want you to have probation. So this is what the court is going to do. And state you may be excused.
Thank you, Judge.
This court is going to sentence you to 3 years deferred adjudication, 100 hours of community service restitution. I'm going to order parenting classes. They're always great when you're expecting.
Thank you.
So I'm going to deduct 50 hours once he completes the parenting classes. The other 50 hours, there's going to be a letter of apology that you need to write to their mom.
Okay.
And once you've done that letter, then your community service hours will, another 50 hours will be deducted from your community service hours. Because sometimes with letters of apology and apologizing to people, sometimes you're not in the wrong, right? But then just apologizing cools down temperatures and then everybody is fine.
Okay. Sounds good.
So I'm gonna order that
Yes.
because that's what they say that they want.
And Your Honor, that's to be turned into probation? To the
Yes.
family directly?
Yes.
Thank you.
There is to be no contact with Nicholas Rodriguez or Romero Rodriguez. There's going to be proof of employment within 30 days, no employment as a home healthcare provider or with minors, regular reporting by Zoom or in person, regular UAs, probation. Is there anything else you would recommend? Thank you. Let's do field visits 1 time per month for 3 months. All right, is there anything else you need from the court to help you?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. In this court, to be successful on probation, communication is key. If there is an issue, let your probation officer know. If you feel they're not addressing it, you can always come back to court and address it with me. What I can tell you is when you have children on the horizon, first off, the grandparents are going to be very excited. They may want to be overly involved, but let them be, because you'll need some help. And sometimes it can get stressful. And because you are doing probation, and it seems like it's a lot, if it gets too overwhelming, just let your probation officer know. You understand?
Yes, ma'am.
All right. Thank you for dressing appropriately for court. Just remain in the courtroom and probation will go over conditions with you.
Thank you.
All right, good
Your Honor, I
luck.
don't know if it's important for the court's file, but he does work nights at this job that he works, so.
Okay.
Reporting in the morning during the day, he'll do his best to get there on time. He always shows up to court on time, but just, he does work nights.
2 to 10 p.m.
All right, be sure to let probation know about that, okay?
Sounds good, thank you.
The worst thing you can do on this probation, of course, other than picking up a new offense, is to not report. You need to report, okay?
Sounds good.
All right,
Thank you.
thank
Thank you,
you.
Your Honor.
You're welcome. All right. Who's here on Leonardo Arredondo? Leonardo. Yes. All right. Deputy Laura on Leonardo Arredondo, if you can make an announcement in the hallway, please. Arredondo, I'm sorry, Leonardo Solis Arredondo. I did the best I could. Thank you, thank you. All right, the court is calling 2025 CR 0020023, State versus Gregory Gonzalez Pruneda. And probation, this is sentencing, and it appears to be an application. All right, could I have parties announce? Counsel, you on this side.
Oh,
Yeah. No problem. All right, this fee bargain page is, let's go off the record. All right, so there's an issue with the plea bargain. The plea bargain says punishments be assessed at 2 years. It doesn't say whether or not the state is opposed to the application or recommending probation.
On the bottom, below the line.
No, they say, I mean, but they're still supposed to say, I mean, are you all silent?
State recommends.
All right,
We discussed that a few minutes ago.
all right.
Below the line. No, my initials on two, Judge.
Yes, please. All right, we're back on the record. So you're here for sentencing. According to the plea bargain agreement, the state is recommending community supervision. They're asking that your punishment be assessed at 2 years in the prison. And they're requesting that your community supervision also be for a length of 2 years. Have both parties had a chance to review the top evaluation and PSI report, state?
Yes, Judge.
Defense?
Yes, Your Honor.
Any objection, state?
No, Judge.
Defense?
No, Your Honor.
All right. So according to the TAP evaluation, they're recommending inpatient treatment. It appears that you do need inpatient treatment. Do you agree with that?
Sure.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Gregory Gonzalez Pruneda.
All right, so they're asking for inpatient treatment, and state you may be excused.
Thank you, Judge.
It appears that you do need treatment. And the reason why I say that is you have previous history where you didn't do well on probation. Your probation was revoked. You were sentenced. And a lot of your cases, they're all drug cases, except for a couple. And in one case, I think this is wrong. They said you were sentenced to 1 year in prison, but I believe that's supposed to be 1 year state jail facility. And then there's another one where you're sentenced to 3 years in prison, and all of this is from drug use. So it appears to the court that you do need inpatient treatment. So here's the thing. I can follow your agreement. You're going into inpatient treatment. You're going to remain in custody, going to transfer you to inpatient treatment. I can ask that he also be referred to felony drug court. Felony drug court, of course, is at capacity. They may have room for him. They may not. They may put him on a waiting list. But I think he needs inpatient treatment. So I can do that. Or if you say, you know what, I don't want to do this at all. They've already agreed, according to your plea bargain agreement, that your minimum, well, the maximum amount of sentence I can give you is 2 years. So you're going into somebody's inpatient treatment program. So if you don't want to do that, tell me now, and I'll just send you to prison for the 2 years. All right, off the record for a moment. Bashan, I'm going to send you an email. It's unrelated to this case, I think that person is trying to go to RMS for testing. Oh, she's still here. Hi. No, she's not. My glasses are off. Oh, that is not you. Okay. All right, so I'm gonna send it to you because I think she went somewhere else. So I sent you the email. All right, we're back on the record.
No, been here since December 30.
So you have a choice. If you want to go to prison, I can send you to prison for 2 years. Otherwise, I'm following this recommendation for inpatient treatment. I'll do, like I say, I'll do a referral to felony drug court. If felony drug court is at capacity or they don't accept you, you'll be going to inpatient treatment because that's what they're recommending.
The judge, there was another, while you were doing that other matter, he was asking about his good time. I can't promise him a good time other than the time he's been, his back time, he's been in jail since December 3rd.
I mean, the only thing I can give you credit for is time that you were in custody, whether they're giving you 2 for 1 or whatever they're doing at the jail, that's completely up to the jail. If I sentence you to 2 years in prison, that's saying at most you're going to get 2 years in prison. So no one can give you more than the 2 years that I was sentenced you to. Now, whether someone is giving you good time credit or giving you, counted it as less, technically as less than the 2 years, that's up to the institution. I have no control over that.
That's what I was talking about.
Yeah.
First on the south side, I'll give it 2 for 1.
Okay, but the PDC, they may give it to you. She's trying to do it. She can't do it. All she can do is give you the back time to do something. It could be 6 months.
So for example, if you have been at the Bexar County Jail for 6 months, and I say you get credit for any time that you've been in custody, at least you're getting 6 months. Now, if the jail is doing 2 for 1, 3 for 1, or whatever they're doing, that's completely up to the jail. So there's no good for you to write me a letter and say, hey, I was supposed to get, 8 months credit because I was supposed to be getting 2 for 1 or 3 for 1 at the jail. That's the jail's calculation. The only thing that I can say is, this is what you're getting credit for.
In this case, would be back to December 3rd.
Okay, and then felony drug court.
Only the drug court will be a conditional.
You said that you would recommend felony drug court?
Yeah, but felony drug court may not be able to accept you because they may be at capacity. And if they're at capacity, you'll be placed on a waiting list and they'll probably send you to inpatient treatment until they have a space for you. And that's a 2-year program. So I will place you on probation for at least 3 years because that program is 2 years. And if you successfully complete that program, sometimes they'll recommend that your probation be terminated early because you successfully completed their program. But their program is a minimum of 2 years.
Judge, he would like to apply for drug court.
All right, but here's the thing. I want you to hear me and internalize what I'm saying because it sounds like you really want to do drug court. I can't force drug court to accept you. If they're at capacity, then they're at capacity. But when drug court interviews you, you need to be 100% honest with them. You understand?
Yes.
All right. So this is what the court will do. The court will sentence you. I'm sorry, because another judge took this plea. Did he enter a plea of no contest or guilty? I'm sorry?
Guilty.
All right. And for the record, the court did read the stipulations and the court is finding that there's sufficient evidence to find you guilty and the court will find you guilty. The court will sentence you to 2 years in prison, suspended and probated for 3 years. With regards to the drug testing, they're saying that, I think I've read it somewhere. They're saying that it's $220 for drug testing. Are you in agreement with that amount? That seems very high.
Well, I was gonna ask that it's normally 65 in that neighborhood. Maybe we got a new lab that charges the county a little more. Gregory says he'll abide by that price.
Okay.
That's a little, it was a little.
Yeah, it's a little steep there.
Yeah.
65. I saw 220 and I was thinking maybe it ran 3 tests. I don't know.
All right, so we'll do 200, but I'm not giving you a fine, so $220 for drug testing. And that's to be given to SAPD. In custody, the following. There's a referral to felony drug court. If not accepted in felony drug court, then SATA. Proof of employment within 45 days of release. No employment as a home healthcare provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. Field visits 1 time per month for 6 months. 60 sober meetings in 60 days. Do you have any children?
Yes, yes, ma'am.
What are their ages?
12, she just turned 12 this month, or last month.
All right, there's gonna be 100 hours of community service restitution. Once he completes parenting classes, the community service hours will be deemed satisfied. All right, probation, is there anything else? Is there anything else you need from the court in order to be successful?
No,
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing, in this court, to be successful on probation, communication is key. If you have an issue, let your probation officer know about it. If you feel that you're gonna use, or that you are maybe backsliding, heading into relapse, pick up the phone, call your probation officer. Your attorney will tell you that once you're placed on probation in this court, I'm hoping that you're gonna be successful. Everybody wants you to be successful. You understand?
Yes, ma'am.
I take no pleasure in sending people to prison, but he will tell you, I will send people to prison, but I take no joy in doing that. So you need to be clean and sober for your 12-year-old. If you're not going to do it for yourself, do it for your 12-year-old. You should be doing it by yourself, but if not, do it for your 12-year-old. And if you don't get your life together and be clean and sober, somebody else is going to raise your child. She's going to be calling somebody else dad, not you. And then the last thing you want is for somebody to have to identify your body because you've overdosed, or somebody is visiting you at the jail. I don't think you want your daughter to have to come visit you at the jail, right? So where you are now in your life, hopefully it's not where you're going to end up. We're all on this journey of self-improvement. So this is a chance for you to improve yourself. I know you've been unsuccessful on probation before, gone to prison before, but this is another chance, an opportunity for you to do better, okay? All right, good luck to you. Thank you. Okay, and you know what? And he's clean.
Yeah, he should be. I was gonna ask you on the thing. I don't know. I had one client that asked about, you asked, have you used?
Mhm.
Well, not since I got out of jail. Sure, the police once were.
Yeah.
But I heard you on a quote. Tell the truth, damn the devil.
Yeah.
That-
Yeah,
is that
tell
the
the
quote?
truth, shame the devil.
Oh, shame the devil.
Yeah.
Thank you, Judge.
All right, thank you so much. Always good seeing you. Yes. Okay.
Yes, Judge, I got a number and I left a message, so if I hear back, I'll let you know.
All right, well, we're gonna take it up. Let me see Arredondo. All right. All right, court is calling 2025 CR 005403 State versus Leonard Arredondo. Can I have parties announced for the state? It's criminal trial division. For the defense.
Dirk Ashball, Mr. Arredondo.
All right, this hearing was scheduled at 9 a.m. It is now 10:50 a.m. Mr. Arredondo did not answer the docket this morning, and he has not answered docket currently. Deputy Laura, did you make an announcement?
Yes, Your Honor, I did. He is not out there.
Defense, have you had any contact with your client?
Not this morning, Judge. I've called and left a message, and I guess if I hear back, I'll let the court know.
All right, state,
This is a commercial and personal bond.
commercial.
Forfeit the bond, issue warrant.
All right, the court will issue a bond forfeiture, remain your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you. All right, who's here on Jason Moore? Are y'all ready to proceed?
Yes, Your Honor.
All right, the court is calling 2025 CR 000924 State versus Jason Moore. Could I have parties announce?
Zach Dunn for the state.
Mario Del Prado, Commissioner Moore.
Are you Mr. Moore?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
At this point, I think, Your Honor, that we're going to withdraw that. He's been accepted in the Veterans Treatment Court, so we're asked the court to.
So, Your Honor, just for, yes, for candor and clarity, of course, there's only one violation with respect to the MTR, one that the state believes they would be unable to prove. And we had let defense counsel know that this morning. And the defense, of course, let us know about the recent Veterans Treatment Court acceptance.
All right, so then here's my, yes, probation.
So Judge, he was accepted into in the Veterans Treatment Court program. However, their orientation for him will not be done until the end of the month. They do not have a set date yet on when he'll be scheduled.
All right, and then, so is he gonna remain in custody until he's transferred to BTC or?
Well, Your Honor, I would think that if there is no MTR pending and there's.
Well, I haven't like signed a motion to withdraw because I haven't received a motion to withdraw. This is what my concern is. My concern is, state, you're saying that you don't think you'll be able to prove up the number one.
I think we're in a difficult position, Your Honor, yes.
So my concern is that the number one hasn't been dismissed. And if he's released from custody, have that out there. And I don't want any issues to occur that he's released, because then we're going to be back here with another motion to revoke.
Yes, Your Honor. Is it potentially, or is it possible, if you will, that I could take care of some things at the misdemeanor level to kind of just make things very clean with respect to his
Yes.
overall circumstance, and then reapproach later on, maybe with a new set of
Okay,
what's existing?
all right, that would be great.
Thank you, Judge. Okay, I
All right,
will
thank you.
physically take off.
All right. All right, so just have a seat. He's going to see about taking care of the issues with the misdemeanor.
Yes, ma'am. Thank you.
You're welcome. All right, court is calling 2024 CR 011954 State versus Dora Bravo. Can I have parties announced?
Megan Galloway for the state.
Michael Bellable from Miss Bravo.
And are you Miss Bravo?
Yes, ma'am.
I'm gonna need you to keep your voice up one so that I can hear and so the court
Yes,
reporter
ma'am.
can hear. Thank you. All right, thank you. Counsel, have you received all discovery in this case and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. Bravo, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, probation, there's an application in this case. Ms. Bravo, did you review the true bill of indictment?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Bravo, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Your charge is possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering that plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Bravo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Ma'am.
According to the plea bargain agreement, punishment is to be assessed at an $800 fine. State recommends community supervision, well, deferred adjudication. They're taking in consideration 2025 AL 005470. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
It is her.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there be any such motions?
No, ma'am.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, community service restitution hours, no contact with Roberto Avalos Jr. and JCPenney stores, the life skills course, and the anti-theft course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
State offers states one in attachments.
No objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
We just asked the court follow the recommendation from the state.
All right, are you employed?
No, ma'am.
How do you support yourself?
My boyfriend,
Who's your boyfriend?
Pedro
Pedro who?
Diaz.
And what happened to Roberto Avalos?
What do you mean? What happened to him?
I mean, you were in a car with him. Is he no longer in your life?
No, he's incarcerated, but nobody stated that I was dating him. I was just getting a ride from him, ma'am.
All right, did you know him before you accepted a ride from him?
Yes, I did.
All right, and how did you know him?
Friend of family.
Do you have any children?
I do.
What are their ages?
He is 15.
And who is the 15-year-old with?
He is with his uncle and his guardian.
And when you're drug tested today, what are you going to be positive for?
Marijuana.
And what else?
Um,
Now, that's not just about it. Do you want to get drug tested today? So here's the thing. I am trying to set conditions for you so you'll be successful in probation. In order for me to do that, you need to be honest with me. All right? So if you use before coming to court, that's not a violation of your probation because you were not on probation. So what are you going to be positive for?
drugs,
Well, I wasn't with you, so what type of drugs?
the kind that for methamphetamines.
All right, so when's the last time you used meth?
Mm, it was 24 hours ago.
Okay. Do you have any family support?
Yes. Concerned fit, yes.
All right, who's supporting you as far as someone you can go to help you maintain your sobriety?
My brother,
Your brother?
my oldest brother.
Okay. When's the first time you started using?
In 2017.
Okay. All right. This is what the court is going to do. There's going to be an $800 fine that will be probated. 3 years deferred adjudication. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be no residing with minors. Take in consideration 2025 AL 005470. There's going to be 100 hours of community service restitution. Once parenting is completed, the community service hours will be deemed satisfied. There's to be no contact with Roberto Avalos Jr. No contact with J.C. Penney stores. Counsel, I'm not going to do the anti-theft course because I think the theft course is related to the drug issues. And I think if that problem is solved, then there'll be no need for the other. But I am going to recommend the life skills course. There's to be regular reporting by Zoom or in person, regular random UAs. In custody, there's to be a TAP evaluation, follow recommendations, and also a referral to felony drug court. Probation is, and field visits, 1 time per month for 6 months. Probation, is there anything else? All right, did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. We can go off the record. This is why you're going in custody. You are extremely high today. And if I allow you to walk out of here, what's going to end up happening is you're going to use more meth.
No.
And who knows what will end up happening? You may get some bad drugs.
Why
but-
couldn't you give me the benefit of the doubt? I just got out on bond. I'm trying to change. I'm doing what I'm.
I know,
supposed
this
to.
is going to help you. All right, thank you.
How long am I gonna be gone? When am I-
Thank you, counsel. It's to help her.
I understand.
And they should be, a felony drug court will probably be able to see her before the week is out.
Okay.
All right.
So she'll be in until the referral is over?
Yes. All right, thank
I'll
you.
explain that to her.
Okay. All right, who is here on Caudell Carney?
Your Honor.
Did you all figure things out?
We asked the court to reset it for Friday or Monday. We're moving very close. We need that time. to be
Okay.
Useful to both sides.
All right, so you all are saying Monday?
If that'd be okay, yes, Your Honor, Monday.
Norma, are we free to do a contested hearing on the 9th if need be? All right, so we'll recall you for the 9th. Mr. Carney?
He's in the back
All right, can you let him know? We'll recall him for the 9th. All right, thank you.
and be excused.
Yes.
Thank you.
All right, who's here on Constance Sinwell? Good morning. All right, where's your client?
She's in custody.
Oh, come on down.
Yes.
Hello. All right, so we are here today because how are you doing with the,
My truck's not doing well, but I am.
yeah, what did you hit? Or no, I shouldn't say that because we're attorneys.
What hit him?
What hit your vehicle?
There you go, thank you.
What made impact with your
I'm
vehicle?
not sure, but I lost my oil can and a tire, so.
Oh, my gosh.
And I Ubered it to court today. That's how dedicated I am.
Oh, my gosh. Hey, I appreciate that. So what we're here for today is an offer was due.
Yes, Your Honor.
So has an offer been tendered?
Yes, Your Honor, the state has conveyed an offer.
All right, so how old are you?
62.
All right. And let me just tell you the reason why I ask those questions, because I'm always trying to consider what would be a good plea deadline date. Sometimes when I have people who are super young, I always say that they need more time because they have to consider the impact or the consequences of the decisions they're making. So sometimes when people are older, they don't need as much time. All right. So what I'm going to do is I'm going to recall this.
Make that date.
Yes.
And I ask you to consider, in regard to the plea deadline, so we didn't like their offer.
No. Surprise. Excuse me, sir. The defense does not like your offer. so-
You know,
However, Judge, we did have some discussions, and I wanted to let the court know that we filed a notice of insanity defense.
Mhm.
And this, both the state and I think that, as a result of the doctor's evaluation, they may see factors that help us, make a counteroffer that they would accept. That's where we ended.
Right. So when is the evaluation for sanity going to be completed?
Well, Judge, I was gonna talk to you about that. I filed the notice, but not the motion, because I need to go to the MAC today and get some names, a doctor, and then I can do that after court and approach the court. That I don't know what the time frame is. I've not done an insanity defense.
All right. Well, usually it may be quicker if you're using your own expert.
Yes, that's what I was gonna do, but I was asking for recommendations. So, MAC is on.
Okay. So this is what the court is going to do. I'm going to recall this, and I understand with defense attorneys, because I was there. You think you have more time than you do, and you look up, oh my gosh, the brief is due. You know that when you ask for a 45-day reset to get your brief together, that 45 days passes by so quickly. You're just so excited that it was approved.
I know that's.
You know, it takes you a couple of days to think about it. Then you look up, it's gone.
Yes.
So what I'm going to do, we're going to come back here. Norma, can we come back on June 23rd? No, today is Tuesday. I'm sorry, June 24th. And we come back here, and what we'll be coming back for is an update on where you are with following your sanity evaluation and how much time that person is telling you they'll need.
Okay, thank you.
All right.
Thank you.
All right. Is there anything else?
nothing from the state. Thank you, Judge.
Thank you.
Thank you, Judge.
Thank you.
Thank you. Who is here on Jesus Zamaripa?
Good morning.
Good morning. How are you doing today?
I'm doing well. How are you?
I'm doing okay. So, Mr. Zamaripa, you need to make sure that you're on time.
Oh, yes.
Right, because if you're not on time, warrant could be issued for your arrest, and then you'll be hearing your case from in custody. You understand?
Yes, Your Honor.
All right. So why were you late today?
Oh, because I was in the room. I was talking to him, my lawyer. We were discussing.
All right. You need to be in the courtroom at 9 a.m. Okay?
My apologies to you.
All right. So today is plea deadline date.
Yes, Your Honor, there has been a change in some circumstances regarding the plea that we had previously received. There was a recently indicted new felony as of late last week. The state has modified their offers to include that new case. Problem is, I have not had the opportunity, because it was recently indicted, to receive the new discovery in that case and review it, to discuss it in full detail with Mr. Zamaripa. If possible, if we could receive a new plea deadline so that we can include all cases for potential resolution.
Specifically indicted May 29th of this year.
The indictment is not.
Okay. How much time are you requesting?
30 days if possible.
All right, Norma, on this case, will you put it the second week in January? The week of, I'm sorry, not January, July.
I was like,
You were like,
yeah.
July, the week of the 7th. And that's their final plea deadline date.
Thank you, Your Honor.
All right, July 10th. And you need to make sure you're here on time. And Norma, that's going to be for that case and also for the new case, which is 2025 CR 006532. All right, thank you.
Thank you, Judge.
All right, John Anthony Martinez.
Understood. Morning, Your Honor. May I approach?
Oh, yes,
Thank you, kindly.
sure. Hello.
Good morning.
Let me see, it's not pulling this case up. Let me try. All right, so today's plea deadline date.
Your Honor, we were just tendered a plea offer this morning. I'm appearing on behalf of Leo Gonzalez. He's the attorney of record for Mr. Martinez. We were tendered, like I said, I conferred with the state. We were tendered a plea offer this morning. My client needs, I need time to relay it, and my client needs time to consider it, Your Honor.
All right,
Thank you, ma'am.
this is going to be recalled for June 5th.
June 5th. So this date, Your Honor,
That's Thursday.
Thursday?
Mhm.
Thank you, Your Honor. I appreciate you.
All right, thank you. Once you sign the reset form and no gum chewing at the bench, okay?
Okay.
All right, so
Morris.
when you come back on June 5th, you need to let the court know whether or not you're accepting the state's offer because
Yeah.
this case has been going on for a while,
Yeah.
okay?
Okay.
All right, thank you.
You know, let's take it.
Who's here? Simon Garza? Hello. All right, is this also family violence or?
No, Judge, this is
Manslaughter.
the
Okay.
case. This is our first discovery setting, Judge. We are having some issues that are a little strange. We do have all of the photos, videos, I believe. We have 0 PDF paper documents. And the state is telling me they are uploaded, but when we pull up by the JN, it tells us there's no case. So we need to bring in a flash drive to get that from him.
Okay,
We have reviewed some of that here in court, so we looked at some of it, but there's still a lot more we need to go through. We did file a bond motion, Judge. We are set for Thursday, but we're prepared to have a very, very short hearing if you are.
well, it's the state.
Judge, I'll be fine with going forward today if you like.
All right, so just 1 second. Miss Ferguson. I need a 30-day reset for discovery. It's on Simon Garza. No, let's do it the following week because people are probably going to be on their vacations or whatever. All right, July 10th.
Remove the Thursday picture?
Yes.
Thank you, Norma.
All right, the court is calling 2025 CR 004128 State versus Simon Alexander Garza. Can I have parties announced?
Jason Garahan for the state, Your Honor.
Marissa Javico and Clarissa Pratt for Mr. Garza.
And are you Mr. Garza?
Yes.
All right, defense has filed a motion for a bond reduction. The bond is currently set at $150,000. They're asking that the bond be reduced to $50,000. Is there an agreement?
No, there's not.
All right, defense, you may present whatever evidence you wish to present to the court.
Thank you, Judge. I'd just like to call my client Simon Garza.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Simon Alexander Garza.
All right, you may proceed.
Thank you, Judge. Simon, how old are you?
I'm 21.
Can you tell the judge a little bit about where you're at in your life at?
I just finished a clinical medical assistant program. I'm a certified medical assistant now. I was going to start my job the day after I had gotten arrested. I was also preparing to study for the EKG exam. My family's here in San Antonio. I have a fiance. I've just recently been engaged, and I'm seeking to marry her soon.
Are you from San Antonio?
Yes.
And you mentioned you had gotten a job. Where was your job?
Texas San Antonio Orthopedic Group.
Rested spontaneously, or did you turn yourself in?
I received a call and I went willingly.
So you turned yourself in?
Yeah.
Okay. And have you ever been arrested before?
No, never.
Okay. And the incident that you were arrested on, when do you know when they're alleging it took place?
I believe October 13th of 2023.
2023?
Yeah.
So it's been approximately almost 2 years, but a year and a half?
Yeah,
Okay. Have you been arrested since this incident?
I have not.
Okay, and were you arrested or told that charges were coming on the day of the scene, or, the day of the incident?
I was not.
Um. Did you have a driver's license on that day?
Yes,
Do you still have your driver's license?
yes,
Um. Do you drink alcohol?
I don't,
Do you do any drugs?
I don't,
Do you have any kids?
I don't.
Okay. What family do you have here?
I have my mother, all my siblings, my father's passed away. I have all of my uncles and cousins as well.
And your fiance lives here?
Yes, my fiance and her family as well.
Okay. And if you were to get out, where would you live?
With my mother.
Okay. Is your fiance living with your mother too, or just?
She's living with her mother.
Okay. And do you know if you still have your job at the?
I was told that I'm able to reapply and work as
Okay.
soon as I'm available.
Okay. The current bond is set at 150,000. Are you able to make that bond?
I'm not.
Have you and your family tried to make that bond?
We've attempted.
Okay. You've called bond company?
Yes,
Okay. Do you own a home?
I don't.
Okay, does your fiance own a home?
She does not.
Do you have any vehicles or any other property that you could sell?
I don't.
If the judge were to reduce the bond to $50,000, do you think that you would be able to make that bond?
I think that'd be, yeah, I'd be able to make that.
I'll pass the witness.
Yes, sir. You stated that you had not been arrested or anything since this incident happened. On October 31st, 2023, were you pulled over for speeding 86 miles an hour in the 70?
I believe.
Yeah, I'm not objecting, it goes beyond the scope. A speeding ticket is not an arrest.
No, that objection will be overruled. I understand what you're saying, that it's not arrest, though.
And I'm just asking if he was stopped for that, not whether he's convicted or not. So at that time you had a vehicle, is that correct?
It was not my one.
Okay. Because I'm assuming that just the vehicle that you were driving on October 13th, 2023 was totaled in the incident. So after you allegedly have sped just 2 weeks after this actual incident happened, is that correct?
Judge, I'm not objecting, it goes beyond the scope of a bond hearing.
Well, with regards to the speeding. So my understanding of the question, and correct me if I'm wrong, the question is whether or not he was speeding, and that speeding incident is unrelated to the facts of this case. Am I correct?
That is correct, Your Honor.
All right, so in considering bond, I have to consider safety of the community. So with regards to his speeding and allegedly, and saying that he was going 83 miles per hour, then the court needs to hear that. So the court will hear that. I don't think it's beyond, and I'm finding that it's not beyond the scope of this. State understands that they're not to get into the facts of this case, but in regards to the speeding, the state is allowed to ask or ascertain that you have the speeding, and then this is alleged to have occurred after the speeding. So that's as far as I'll allow the state to question him about the facts of the case. You may continue.
And Judge, I'll move on. I mean, since I believe I've already presented to the court of the community's safety reasons. Now, you say you have family, probably friends here. Have you gone about trying to borrow any money? Have you gone about having any type of raising money for you to actually make this bond at all?
We have.
And how much have you raised?
I'm not sure that the actual.
Okay. And then in this current case, you're aware that you're charged with manslaughter, correct?
Yes.
And you're aware that somebody has died.
Um,
And any other assets, for instance, how do you get around, or before you were arrested, how were you getting around town?
I was taking the bus for a while, and then somebody had offered me a vehicle to use.
And I'm so sorry, could you speak up a little bit
So
so I
just
can
speak
hear?
that way, so the judge.
Yeah.
I was taking the bus for a while and then somebody had offered me a vehicle to use.
So currently you have access to vehicles or a vehicle and you are driving here in Bear County, Texas. Not currently, obviously, you're in jail, but I mean, I'm saying previous to your arrest.
Previous to my arrest, I did have limited access to a vehicle.
No further questions, John.
Just very brief follow-up. Simon, how long have you been in custody?
About a month.
Okay. And on the day of the incident, you were still on the scene when police arrived, correct?
Yes.
And in fact, you were assisting with the crash and the victims.
Yes, I was.
So you didn't flee the scene. Police had an opportunity to arrest you if they wanted to.
That's right.
Nothing further.
All right. Any further witnesses?
No, Judge, we rest. Just
Any other evidence, state?
Not for the state.
All right.
We would ask for the
Let the
report, yeah.
I can make it.
You can
I
stipulate
could,
to-
well, I can stipulate the facts. if you like. Yeah. Would you like me to? Sure, you can.
Judge, just for the record, this was a vehicle accident. The police, they're alleging that a red light was ran and then there was a crash. That is the totality, I believe, of the facts that you need to know if the state, yeah, no alcohol, no drugs. They didn't even do field sobriety tests. The officer put in his report that he had no suspicions that our client was under the influence. If the state has any discrepancies or anything to add to the facts.
Nothing that, I mean, that's a very general rendition of the facts, obviously, Judge. And it's a red light, allegedly a red light that the defendant had, and that the victim and the occupants in that vehicle were turning left onto a road with a green light. And there is video of it that was shown to defense counsel this morning. And the driver of the vehicle turning the victim was the actual driver, and it was T-boned at that intersection. And again, as defense counsel did present to the court, there was no indication of alcohol use, and DWI officers were on scene.
Just so you have a general awareness of what the charges are, Judge, and then we have nothing to start from it.
All right, I'll hear argument.
Okay. Judge, Mr. Garza is a young kid, but he has no criminal history. He's never been arrested, not even since almost 2 years since the date of the accident. This is exactly that. It is a vehicle accident. He is not a danger to society. He's not a danger to our community. He is a nurse for all intents and purposes. He is hardworking, has family here. He's ties to the community. There's no indication that he will flee. There's no indication that he will not show up for his court dates. And bond is not meant to hold somebody. It is meant to ensure that they will appear. And for that reason, he has also stated that he cannot make this bond. And we are arguing that it should be lowered because there's no reason to hold him at 150,000. It's excessive given the facts. So we're asking for 50,000.
What about the safety of the community? Because the evidence that the court has received is that previously, before this alleged offense, and I'm not taking this offense as true, but both sides have just given me a rendition of what the police report says. But prior, under questioning, he's been stopped for going 83 miles per hour. And I think state said that ended in a crash, or no?
Judge, if you may, if
Yes.
I may, one, the manslaughter case that we have where he's in an accident running a red light, that is on October 13th, 2023. And then what I've got from the accused here is that on October 31st, roughly a couple weeks later or so in 2023, that's when he was not arrested, but ticketed for 83 or 86 miles an hour in a 70-mile-an-hour zone.
Okay, so do you want to address that?
Judge, we will happily agree to no driving, but I mean, people speed every day in our community. That doesn't necessarily mean they're a danger. This was one incident. If we agree to no driving any vehicles, I think there's no danger to society.
All right, state.
State's position obviously is that, I mean, it seems obvious that it is a danger. to speed at any point, and it's especially after you've had a fatality accident or incident where a manslaughter is possible. Roughly 2 weeks later, you're going 86 in a 70-mile-an-hour zone. So the state's position is it is very dangerous, and that the individual has not presented that the fact that he couldn't make $150,000 bond, but that the fact that he has possibly tried, but doesn't even know how much money has been raised or not raised, Judge. That's the state's position. It's just remain at $150,000.
All right, I'll give you the final argument because it's your motion.
Thank you, Judge. Just briefly, the state is saying that this is a seriously dangerous person to our community, yet they waited 1.5 years to file this case. If he was such a danger, why wasn't he arrested sooner? There has been no incidents since the date of in 2023 that have caused any concern, and he has not been a concern to the state until now.
Okay.
There is no danger, Judge, and we're asking for 50,000.
All right, so just give me a moment. I'm gonna think about this. Give me like 10 minutes. You're welcome. All right, are you all ready on yours? All right, if y'all can come forward. What is your client's name? It is Moore. All right, yes, on Mr. Moore, what have you all come to?
So, Your Honor, that is a dismissal for the misdemeanor cause number.
Okay,
That council will walk down to the appropriate floor to basically hand it over.
all right, and what's the cause number?
The cause number is 2025 PF 08342.
He's reading my very good handwriting, Your Honor.
Fine.
All right, so then now you said that he's been accepted into the VTC.
Yes, Your Honor. And if my understanding is correct, this was an original condition of his probation, so we're essentially just asking for that to be continued.
Okay. Probation. Hi. On Mr. Moore's case, they've done a dismissal on the misdemeanor. So they're saying that they're referring him to VTC and he's been accepted into VTC. So you all are withdrawing the motion?
Yes, Judge.
All right, and with regards to the dismissal case, do you all want to no contact with the complainant? Is that necessary?
I can say that we've reached out now 3 times to no avail. Initially, they had notated some cooperativeness with our office, so it would be hard for me not to want to no contact, but in full candor again, and we've told this to defense 3 times now, we've reached out to no avail. So it made it very difficult.
All right, so who is the complainant in the misdemeanor case?
His mother, Your Honor.
Moms love their children. They always love their children. But you all are gonna have to figure out how to have a relationship. If you're gonna have a relationship, that's a positive relationship. Otherwise, you're gonna come back before me and there may be another case. Do you understand?
Yes, I do. Very much.
All right, and you are on deferred adjudication, and I think this is listed as a 3rd degree. So, I'm sorry, no, it's listed as a 2nd degree. So you're looking at potentially 20 years in the prison. You understand? So Veterans Treatment Court is a good program. Make sure that you do everything that's asked of you. And when you graduate, if I'm in town, I will attend your graduation. Notice I said when, not if, okay?
Thank you.
All right, good luck to you and thank you for your service.
Thank you very much.
I just want to tell you, Judge, that this morning I did speak offline and he is excited about the program. I'm gonna give him the contact information for Mr. Leaf. And he has assured us that he is going to go forth with the orientation.
All right, don't make sure you don't miss anything. And if for some reason something comes up, which I know it will not, you need to get in touch with probation. If you're having problems contacting them, get in touch with probation. Don't wait till the last minute, all right?
Yes, ma'am.
And again, of course, if there's anything you're having issues with and you feel that other people are not addressing it, you can always come back here, okay?
Yes, ma'am.
All right, good luck to you.
Thank you very much.
You're welcome.
Thank you, Judge.
Yes.
Thank you.
All right. We're back on the record in 2025 CR 004128, State versus Simon Alexander Garza. All right, this is going to be the court's orders with regards to the bond reduction. I am going to grant the motion to reduce the bond. I'm going to reduce the bond to 100,000. And there's to be no driving. Are there any other conditions that are requested from the state?
State be requesting GPS, Your Honor.
All right, there'll be a GPS. I'm gonna ask that the fees be waived. They will be waived as long as he does it through the jail.
Judge, can we request partial and so he can find another job?
Are you, do you want tracking or partial?
State will agree with partial.
All right, so there'll be partial for employment. Is there anything else?
No, you're, do you require an affidavit of non-strategy?
Yes. All right, thank you. Ms. Ferguson, if you'll give him a reset form, please. All right, who's here on Melinda Gonzalez? Oops, sorry. And is this an application for deferred?
Yes, Your Honor. It's going to be for the lesser included, Your Honor.
All right. All right, court is calling 2025 CR 003315 State versus Melissa Gonzalez. Can I have parties announced for the record?
Zach Dunn for the state, Your Honor.
David Andre Woodard for Ms. Gonzalez.
And are you Miss Gonzalez?
Yes, I am.
Counsel, have you received all discovery? Did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Ms. Gonzalez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor. The state is proceeding on the lesser included offense, a Class A misdemeanor.
Any objections?
No, Your Honor.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
All right, the state is proceeding on the lesser included offense of assault causing bodily injury as family violence. That is a Class A misdemeanor. The range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes, I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I did.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
She is, Judge.
Ms. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, I am.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of assault, bodily injury, family violence. They're recommending deferred adjudication. This is run concurrent with 2024 CC 740127. We're taking in consideration 2024 PF 22550, and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be your plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 1 year. and there be no contact with the complainant. Did you understand those were recommendations from the state? And the court does not have to follow those recommendations.
Yes, I did.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offer states one and attachments.
No objections, Judge.
All right, and state, have you spoken with the complainant?
Your Honor, the complainant has indicated their lack of cooperativeness with the district attorney's office.
All right, thank you. You may be excused.
Thank you, Judge.
Did you review the stipulations with your attorney and the waivers?
Yes,
Did you understand it and sign it in all the appropriate places?
yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
We just asked the court to follow the recommendation, Judge.
All right, so what's going on in your life? Why are you doing this?
I have a problem with alcohol, but I owned up to it, and I did take some classes, some rehab classes, and currently on my second DWI, but I'm learning from my mistakes. And I also was on CPS, and to this day I can't even see my daughter because my dad, I can't even be around my dad, so I can't even be around my daughter. CPS case got closed, thank God. I just want to be back with my daughter. I missed her whole kindergarten year, and I just want to be back.
But see, here's the thing, part of being clean and sober, when you're learning from things, you got to own up to your role. It's
Exactly.
not like, these were not mistakes, these were choices. I have yet to meet somebody who said, you know what, my intention is to go out and drink and get intoxicated. Nobody ever says that because nobody ever thinks they're going to pick up a DWI. But it happens because people don't plan. But people do make choices to drink, right? And then this whole thing with your father, you should probably be grateful that there was somebody there to take your daughter in. Because if it wasn't for your father, then your daughter probably would have been taken in by a complete stranger. And I used to do CPS cases, and you know what ends up happening? That family is supposed to be there. The foster family is supposed to foster your child until you're back on your feet. But usually what ends up happening is the foster family falls in love with the child, right? And they want to keep the child. And then based upon your actions and what you've been doing, your parental rights could have easily been terminated and your child would have been adopted by complete strangers because they love small, young children, right? So instead of saying it's your father's fault, that's what you make it sound like it's your father's fault. You can't see your child. It's not, it's yours. Yeah. And I will tell you right now, until you get your life in order, yeah, your father needs to protect your daughter. Maybe if you get your life together and show your father that you're doing better, that you're not drinking, that you're maintaining your sobriety, maybe I'll consider lifting the no contact order and maybe he'll consider allowing you to see your daughter. But right now, you got to get yourself together. So you only have the one child?
Yes, ma'am.
All right. Are you employed?
I am.
What do you do?
I'm a cook at Twin Peaks.
Oh, okay. See, people come and they say they cook. Then my question is, what is your specialty there? What are you cooking? I've never been to Twin Peaks.
We have all kinds of things, steak, shrimp, salmon, pizzas, wings.
If I were to go there, what is something that I should just say, hey, this is what I'm ordering?
Depends on what you like. I mean, me personally, I would go for a steak.
All right. So I'm gonna have to go to Twin Peaks and order a steak. And if it's not any good,
On me.
all right. If it's not good, I'm gonna be like, hey, Melinda Gonzalez told me to order this. I was gonna do the shrimp, but okay.
Or the shrimp and chicken is good.
Okay. All right. I'm gonna try it. I'm always interested in when people say they work at different restaurants, what I should try. All right. So where you are today, not gonna where you're gonna end up. We're all on a journey to improve ourselves, right? So you still have a chance to be in your daughter's life, but you're gonna have to do your part, okay?
Exactly. Yes, ma'am.
All right, it's going to be 1 year deferred adjudication. There's an affirmative finding of family violence, regular reporting by Zoom or in person. Off the record for a moment. And to your note, she doesn't have to come back if you all have done everything. All right, back on the record. Regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home healthcare provider or with minors. There should be no contact with the complainant. That's Rudy Gonzalez. This will run concurrent with 2024 CC 740127, taking consideration 2024 PF 22550. There's going to be 80 hours of community service restitution. I'm going to order parenting classes. Once you completed those, the community service hours will be deemed satisfied. Field visits 1 time per month for 2 months. And then do a TAP evaluation out of custody. Follow recommendations. Are you doing any sober support meetings?
Sober support? Yes, my family,
All right, how often do you do them?
every day.
All right, so we're gonna do 60 sober meetings in 60 days. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, Your Honor. Thank you so much.
Oh, you're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, I did.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. I want everyone to be successful on probation. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can always come back to court and address it with me, all right?
Thank you so much.
All right, good luck to you. I'm gonna try that steak.
Thank you.
All right,
Have a
bye-bye.
good day.
Thank you.
I think we have a resolution. Get Ms. Testing on the right.
I keep trying to put her on the right track. She doesn't want to go on the track.
She wants to now.
I'm like, here's the path. I always give people 2 choices. I'm like, here's the path to prison. Here's the path to improving your life. And people sometimes just choose prison. We're not on the record. Why are you choosing prison?
Your Honor. I'm trying to get a job and get on my feet, get a space to live. I even started parenting classes in prison, in jail.
But see, I mean, you keep doing these things and coming before me. And what do I always tell people? If you have an issue, you can come back to the court. We can try to figure out what's going on. And I always tell people, stop hanging your life, or what do they say? Hanging somebody on the stars and moon. You're thinking like this one person is going to be the person to change your life. And I really need this person in my life. And we're doing great when all, you know what we need to do? When you find chaos in your life, you need to calm down and you need to work on self before you try to get in a relationship. Because usually when you're in your own turmoil and chaos with criminal cases, you know what ends up happening? You attract people who have chaos in their life as well. And usually that person is not a good person. So what are you guys talking about?
Sure. Go ahead.
On the new charge, Judge, she's going to enter a plea. It's going to be a 1244. On the case she's on probation for, I think we're going to agree to inpatient treatment. I believe it was with ISF. I think primarily to get her the coping skill that she needs to make the right decisions, because it's clear she hasn't been making the right decisions. That's probably why you know her on a first name basis, because she's been.
Well, I mean, I know her because I remember the first time she came in. Then I remember the next time she came in, she was wearing yellow because she was pregnant. And then I remember the next time she came in, we were doing updates. Everything was going fine. I knew she was going to slide or fall off the rails because she ended up with somebody. And I was like, this is not going to work out. Usually, again, sometimes you meet a guy, that guy is fantastic. It's like out of a Hallmark movie. You know, but the Hallmark movies, what ends up happening, Some lady is stranded on the side of the road and some guy picks her up. And it turns out that he owns a company in the town. He's a millionaire. One time, my mom and I were watching a Hallmark channel and the lady ends up marrying this millionaire. And guess what ends up happening? He ends up dying. We're like, this is supposed to be a Hallmark movie. And you know what ends up happening? She meets another millionaire. They end up getting married. So I knew that with the guy you had chosen, yours was going to turn into a Lifetime movie as opposed to a Hallmark movie. You got to get yourself together. So probation, this is what you all want to do? Give her another chance? We don't know. Are we sure about this? Let me ask you, are you available to come back this afternoon by Zoom?
Possibly can, Judge.
All right, can you do it by Zoom? Because this is something I'm gonna have to think about, okay? It appears that you all have an agreement on the 1244, so I'll look at that.
Okay.
And then the probation thing, I just really need time to step back and look at things, okay?
And just so you know, Judge, I've dealt with Ms. Tesley multiple times, and she just seems like a different person this morning from when I'm usually dealing with, because usually she is kind of bucking any type of treatment. Because the state did give her two options, either prison or treatment. And I told her she would likely do more time in treatment than she would possibly in prison. And she said, no, I would prefer the treatment.
All right. So, and the other reason why I'm going to call you back, because I have a judges meeting that I have to be at. and some important decisions are going to be made. 1:30.
1:30 is fine, Judge. I can resume by 1:30.
All right. So Ms. Ferguson will give you the Zoom link and then we'll do everything else. Okay. All right, everyone. We're going to be in recess till 1:30. I'm sorry, Mr. Bud Ridnour, are you able to do it by Zoom? Okay. 2025 CR 0000700, 2025 CR 0000701, State versus Felipe Reyes. Can I have parties announced? All right, I've been informed that the jurors have reached a verdict. Deputy Laura, you can bring the jurors in. All right, everyone, please be seated. Ladies and gentlemen, it's the court's understanding you've reached a verdict. Is that correct? And is the verdict unanimous? All right, Deputy Laura, if you will pass the verdict form. All right. Count one, it says, we, the jury, find the defendant not guilty of count one. Count two, it says, we, the jury, find the defendant not guilty of count two. And in the cause number ending in 701, count one, it says, we, the jury, find the defendant not guilty. And count two, it says, we, the jury, find the defendant not guilty. Does anyone wish to have the jury polled? All right. Thank you, ladies and gentlemen. I'll come back and speak to you briefly. All right, Deputy Laura, if you can have the jurors go back.
All right.
All right, the court is calling 2024 CR 01309 and 2025 CR 000240, State versus Allison Settle. Can I have parties announced?
Will Brooks for the defendant, Ms. South, Judge.
And are you Ms. Settle?
And
Counsel, have you received all discovery in each of these cause numbers? Did you review them with your client?
Yes and yes, Judge.
In each cause number, the court will find that the state is in compliance with discovery. Ms. Settle, did you review the documents entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment in each of these cause numbers with your attorney? Did you understand it?
yes, sir.
Counsel, do you waive the reading of the indictments?
We do, Judge.
All right, and cause number 2024 CR 013090. It appears state that you're proceeding on count one, you're waiving count two and the repeater enhancement allegation. Is that correct?
That's correct, Judge, and that should be the case for both causes.
All right, any objection?
No objection, Judge.
And each cause number, did you see the court review the court's admonishments with your attorney? Did you understand it?
Yes, sir.
And did you sign it in all the appropriate places?
I did.
And the cause number ending in 90, you're charged with unlawful possession of a firearm by a felon as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If I grant your application for deferred adjudication, if for any reason your deferred adjudication will revoke, the court could sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
And the cause number ending in 40, you're charged with fraudulent use or possession of identifying information. 5 items to 10 items of the elderly as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
And each of the cause numbers, if you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent off the record. Deputy Lord, could you make sure they bring out Miss Chelsea? All right, we're back on the record. Did you understand by entering these pleas, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in each of these cause numbers? Counsel, has anyone threatened, counsel, has your client been able to provide with any defenses?
She has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Settle, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No, Your Honor.
Anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
I am.
Court will find that this defendant has knowingly and voluntarily waived her right to jury trial in each cause. In each cause that you review the plea bargain page with your attorney, did you understand it?
Yes, sir.
In each cause, the state is proceeding on count 1 and waiving count 2 in the repeater enhancement allegation. They're asking that your punishment be assessed at a cap of 6 years in the prison. There's $1,000 fine. The state is opposed to your application for deferred adjudication or community supervision. The cause numbers will run concurrently. And the cause number ending in 90, you're to follow conditions listed under 2025 CR 00240. And in that cause number, there's to be no harmful or injurious contact with the complainant and family. There's to be no contact with Vargas, Thurston, Uriga, Getz, and Creamer. Did you understand that to be the plea?
Yes,
I'm
sir.
sorry, but that's the way I said. It's Creamer, Creamer. Is that how you pronounce it?
It is, Judge.
Is it Creamer? I think it's Creamer.
Richard Creamer, Judge.
Thank you. Okay.
Dr.
All right.
Dr. Richard Creamer.
Just a second. All right, so we're back on the record. Did you understand that to be the plea in each of these cause numbers?
Yes, sir.
Defense?
Yes, Judge.
State.
Yes, Judge.
All right, did you review the waiver of appeal paragraph in each of these cause numbers with your attorney? Did you understand it and sign it in each place?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
Motions, I think we had rulings on a bond motion, but otherwise no other rulings, Judge.
And the cause number ending in 40 outside the agreement, they're asking that you have no contact with Rudy Rodriguez. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes, sir.
Then in cause number 2024 CR 013090, how do you plead to the offense in count 1? Guilty, not guilty, or no contest?
No contest.
And in cause number 2025 CR 000240, how do you plead to count 1?
No contest.
All right, state any evidence to support the defendant's plea?
States one attachments in each cause, Judge.
No objections to states one or attachments in either cause, Judge.
All right, in each cause number, did you review the documents entitled waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachment in each clause number, the court will find there is sufficient evidence to find you guilty. However, the court would defer finding of guilt as you've applied for deferred adjudication. All right, we can go off the record. So they're telling me it's taking about 8 weeks for PSI to be done. So we can do the 8 weeks, or if you would like, I could set it sooner and you can have witnesses come in and testify. Which do you prefer?
Judge, I think a PSI needs to be done. I think more important would be a screening for drug court, Judge, and then a McMyoff evaluation as well.
All right, so in each cause number, I will request then the PSI, a TAP evaluation, McMyoff evaluation, and a referral to felony drug court. Norma, what date?
July 28th.
All right, we'll come back on July 28th. And at that time, I'll make a decision on your application. You need to make sure that you make all of your appointments. Normally, you will have an appointment that you meet with a probation officer. These other appointments, they're completely separate, so you'll be given completely different days for them. All right, is there anything else?
Judge, if I may, she is currently on. So she's got a GPS device, Judge. We've had some modifications in the past. Currently, she's living at Haven. And she's getting services there. She's a new mother and she has possession of the child. There's a ton of appointments and things she has to go through, both for services and then for the baby. The challenge has been asking her officer and her officer coordinating all the different things she has to go to. Become cumbersome for the officer as well. That's the court to consider switching possibly to tracking. A lot of times, I think we'll have full house arrest. We're concerned about protecting victims, we're concerned about the person fleeing, but she's demonstrated a propensity to show up to court. And she knows what the restrictions are in respect to some of the complaints are strange, but in respect to her family, Judge.
All right, and where's the child right now?
My mother is watching her.
Yeah. Mother's one of the complainants, Judge.
Okay.
But she knows not to bring a child to court. That's why she was.
No, I mean, I'm always concerned if, yes, do not bring children to court. But if you're not, I'm hopeful that they're in a place that's safe.
Absolutely.
All right, state, what do you say? So this is through pretrial?
Yes, Your Honor.
All right, who's the pretrial officer?
Genesis Ramirez.
All right, Ms. Ferguson, you have Genesis Ramirez zoom in, please?
Ramirez?
Yes. I just have to see, we're gonna have your pretrial service officer zoom in.
Thank
Officer Ramirez? Officer Ramirez, there you are.
Hello, good afternoon.
Hi, good afternoon. Thank you so much for zooming in. It's on Miss Settle, Allison
Yes.
Settle. All right, so defense is saying that she has a lot of appointments that she has to attend. What appointments would those be, defense?
Mostly doctors, stuff for my daughter and then housing.
All right, so the doctor's appointment, I'm assuming that there would be no issues with doctor's appointments? Officer Ramirez?
Oh, yeah, sorry. No, there's no issues. And she's been very good as well with communicating with me every time she has appointments. She makes sure that she emails me 24 hours ahead of time. And then she's also really amazing at providing me every doctor's note every time she goes to the hospital, every time she goes to the doctor. She always provides all her doctor's notes, and I have all those as well.
All right, so there's no problem with her going to the doctors.
No problem at all. Yeah.
I think it's just the process, Judge. That's why I was
Mhm.
asking. So Officer Ramirez, I was asking the court to consider alternate amending to tracking only.
Okay.
And would that be easier for you? In other words, is it a pain to log the requests and the,
I mean, I wouldn't say it's a pain, but it is a lot because I know Miss Allison has had a lot of appointments. I know with her baby, she's been going to the doctor a lot recently. And so, I mean, I have also told her to try to file that motion to either tracking only or to get the GPS removed. So that way it can make it easier on her. We always say, like, if it's an emergency, you can go no matter what. Just make sure you provide the paperwork stating you were there. But yes, it would make it a lot easier that way. She can come and go to the hospital as she pleases.
thank you, officer.
Mhm.
All right, thank you. So here's my issue. What I've discovered is when you have people who have addiction issues, everything is going great because they're being held accountable for every single thing that they do. But then when you say, oh, we're just going to do tracking only, then people start backsliding. And I don't want that to happen. And that is my concern.
Understood. All we can do is make the request,
Yeah.
Judge.
So I don't know, state.
I appreciate that she's been compliant, Judge. I'm not vehemently opposed to her request for tracking only. If this court is inclined to grant tracking only, I would just ask that she abide by the no harmful and injurious contacts and no contacts listed in the agreement.
All right. Well, I tell you what, I'll do tracking, but it'll be tracking with a curfew.
Judge, I think that's fine.
So if y'all want to figure out a curfew time, y'all can figure out a curfew time.
Oh, in the morning, 8.
It would do 8 to 6, Judge, or 8 to 5.
All right. So, state, what do you say to 8 to 6 p.m.?
Agreeable, Judge.
All right. So she has tracking, but she can be out and about from 8 a.m. to 6 p.m.
Thank you, Judge.
All right. Thank you.
Thank you, Judge.
Appreciate it. May we be excused?
Thank you,
Yes.
Mrs. Ramirez.
You all may need to do an order because they'll have to put in the order and we'll do it. But it starts today.
Thank you, Judge.
You're welcome. All right. Thanks.
Thank you.
Yeah, officer.
Thank you so much for
All right,
zooming in.
bye-bye. You're welcome. Bye-bye.
All right. Who's here on Telsey?
It's Mr. Woodard. He should be on Zoom. Judge.
Yeah, he's on Zoom. Court is calling 2025 CR 003892, State of Texas versus Lisa Telsey. Can I have parties announced for the record? State. Defense.
David Andre Woodard from Miss Telsey.
And are you Miss Telsey?
Yes.
Do you have any objection to your attorney appearing by Zoom?
No.
Counsel, have you received all discovery? Did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Ms. Telsey, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Telsey, did you review the court admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you understand, and did you sign it in all the appropriate places? Did you understand you're charged with theft of mail, no more than 30 items, but no less than 10 items?
Yes, ma'am.
That's a state jail felony. Range punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, sir.
Did you understand by entering this agreement, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into an agreement in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
She has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
She is.
Ms. Chelsea, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 58 days in the Bexar County Jail. There's a $500 fine, and the state is asking that you be sentenced under 1244. Did you understand that to be the plea?
Yes.
Defense is at the plea?
It is, Judge.
State is at the plea?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Did offer states 1.5.
No objections, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
We're just asking the court to follow the recommendation.
All right, why are you doing this?
Because I just want to get back to my life and back to my kids.
I don't understand how stealing, I'm saying, why are you stealing?
Oh, I didn't mean to steal.
No, I mean, you did, but if you go into somebody's mailbox that's not your own and you take what's inside the mailbox, that's stealing and you intend to do it. If you break into a mailbox, you're actually breaking into a mailbox. What do you mean you didn't intend to take mail?
I wasn't thinking. It was a bad decision on my part.
All right, court is going to find you guilty. The court has sentenced you to 58 days in the Bexar County Jail under 1244. Give you credit for any time served. There's a $500 fine. Time and money run concurrent. The court will find that the judgment is satisfied and there's to be no contact with Shelton Burnett, Burnette. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? Forever, it should be forever, but I can't give you forever, but it should be forever because you all are out committing crimes. You shouldn't be together. You're not a good couple to be together. You're toxic together, or maybe you're toxic as individuals. I don't know. And that should be the least of your concerns. Because if anything, if he were a good partner to you, he would have been saying, hey, we shouldn't be breaking into these mailboxes. They're not ours. But everybody's trying to get fast money. And I will tell you this, the people whose mailbox you broke into, guess what? Maybe they were waiting for their check. Maybe it's somebody who's waiting for their Social Security check and they don't have it because somebody broke into their mailbox. I don't know why people won't get a job, a job. If you want something, you get money for it. And then, oh, I want to get back to my children. You should have been thinking about that when you were breaking into mailboxes. Were your children with you while you were breaking into mailboxes? See, you should have been with your children, but instead you were with this Sheldon Burnett person. Where were your children doing this?
I don't think I had them yet.
Hmm?
I don't think I had them yet.
No, this occurred while you were on probation. What do you mean? Didn't this occur while you were already on probation?
Yes, ma'am.
Counsel, was she already on probation when this was happened?
It was 2 months afterward, Judge. She was placed on probation September 2023. This happened December 2023.
So you're already on probation. And you shouldn't have been picking up new cases. Instead of doing what you're supposed to be doing, you decided to go out and break in people's mailboxes. All right, the court is calling 2023 CR 6472 State versus Lisa Telsey. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Lisa Shanta Telsey, who was placed on deferred adjudication in 2023 CR 6472 for the offense of assault of a peace officer or judge on September 20th, 2023 for a period of 8 years? Is that you? All right, state.
Violation of condition number 1 on or about the 20th day of December 2023 in Bexar County, Texas. The defendant, Lisa Shanta Telsey, committed the offense of theft, mail 10 to 30 addresses in violation of condition number 1.
How do you plead to that? True or not true?
True.
State.
There are no more.
Oh, do you waive the remaining?
Yes.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty and sentence you up to 20 years in prison and up to $10,000 fine?
Sure.
Knowing that, do you still wish to plead true to violation of condition number 1? Well, so let me just explain something to you. Whatever agreement you worked out with the state, with your counsel, I don't have to follow that agreement. Because this is a contract with the court, it's not a contract between you and the state. So, for example, hypothetically, if the state were to say they want you to be continued, I don't have to continue you. I can send you to prison for up to 20 years. Do you understand?
So,
Knowing that, do you still wish to plead true to violation of condition number 1?
yes, ma'am.
All right, the court is finding violation. Just 1 moment. Is violation of condition number 1 in the supplemental?
Yeah. The copy that I have, Judge, it just says motion to finish. I don't know if it's gonna take.
I think I was given the wrong one. All right, and that's why you're saying there are no, because I had other conditions. All right. All right, thank you. So is there a proposed agreement?
Judge, the proposed agreement for the court's consideration is to alter and amend the defendant's conditions to include respectful treatment with state advance.
All right, why should I follow this? Because she was with Rosetta's Key. Am I correct? Probation?
Yes, Judge.
Was she with Rosetta's Key before?
Yes, Judge.
Was she ever with Apple Home?
I don't.
All right, so what happened with Rosetta's Key?
I was going there and when I went to my probation the last time the cops had arrested me for the old charge that y'all are talking about right now.
All right, probation. What are your thoughts on this?
Judge, the court summary, according to the court summary, they do vertical the state ISF, Judge.
I don't think state ISF, well, that, I don't even think that addresses issues.
I know, Judge, that in the past, we've seen Ms. Chelsea and she has been dishonest, with her officers, and I would like to point out that she completed her anger management. Other than that, Judge, that's all I have.
I mean, well, we were having compliance issues in March. And then she has a new case. I just don't think you should be continued. I don't know why I would continue you on probation. It doesn't appear that you're a good candidate.
And Judge, if I can address, I guess, the timeline regarding the new
Yes.
offense.
Yes.
She was placed on probation in September of 2023. The offense date on that new charge is December 2023, but it wasn't indicted until 2025, I believe. So almost maybe a year and a half, getting close to 2 years later. As I spoke with the court this morning before we broke, I have seen a change in Ms. Telsey from previous times when I represented her. Initially, my thinking with her was she wasn't very serious about probation, about what she needs to do to be successful on probation. But this morning, it seems like she wants to kind of get things in order. I know it's taken a few times of coming before the court to get to that mindset, but it seems and appears that that's where she is right now, where she wants to get back on the straight and narrow. She's still young. She does have a small child out there that hopefully eventually she can reunite with. But I think she has to get past her issues she's had in terms of making poor choices and poor decision making. So I understand the court's reservation in continuing her, but I still think Ms. Telsey is salvageable in terms of completing her probation and being successful, a successful human being in society.
State.
Yes, Judge.
All right, this is what I'm going to do. I'm not going to make a ruling today. Counsel, you can see if felony drug court is willing to accept her. So, Ms. Abrams, on her, I'm not going to make a ruling today. Can you all see if felony drug court would accept her? David Woodard would look into it.
With that, Judge, I just have other concerns. She was placed on the high risk caseload back in March. And even after that, it seemed we had some dishonesty and just not being compliant in certain things. I know that felony drug court is very, very strict on everything, and I just don't know that she would be successful there, Judge.
Your thoughts? Felony drug court is extremely strict. And they are more strict than I am with regards to my conditions.
I feel like I can do it.
So, I mean, I haven't made a decision. I'm not going to make a decision. I'm going to see first whether or not Mr. Woodard, whether or not felony drug court will accept her.
Okay, Judge.
So if you can look into that, then we can come back. And I'm going to recall this for sentencing. Oh, Norma, let me see. Norma, can you recall this for the week of, let's put it for, are you available, Mr. Woodard, on June 12th?
I am, Judge.
All right, so Ms. Ferguson, if we can recall this for June 12th for sentencing.
Yes, ma'am.
All right, thank you.
Thank you, Judge. May I be excused?
Yes, you may be excused. All right, Mr. Flores.
Second bottom here.
All right, today,
Yeah.
I have you all listed for plea deadline date.
That's a mistake, Judge. And I think what happened was this,
Okay, another judge did that, okay.
well, yeah, so I think what happened was last time that we were supposed to be in court, I was in trial. I've been in trial for the last 6 weeks, so it's been a little hectic. Because I saw that too, and I couldn't figure out why. Today's the first day we've actually received a plea offer.
Okay.
Also, Your Honor, I found out he has another first degree felony, which I didn't realize was out there. It's a dope case, but I was gonna ask to see if we can consolidate down to one attorney. We have a global offer we're kind of working on, and we'll have a decision for you by next time whether or not we're gonna need a trial or if this is gonna be a plea.
All right, so you want to bring it back the week of June 23rd or the week of July 7th?
Let's take a look. If we can do it before the week of June 23rd works, only day I won't be here is the 27th of
All
that
right,
week.
Ms. Ferguson, do you have room for the week of June 23rd? What date?
The 23rd.
That works?
All right, we'll see you back on the 23rd.
All right, thank you, Judge.
Thank you. Court is calling 2025 CR 003823 State versus Charles Fleming. Could I have parties announced?
Second Galloway for the state.
Michael DeLeon for Mr. Fleming.
And are you Mr. Fleming?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor. Yes.
Court will find that the state is in compliance with discovery. Mr. Fleming, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes,
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes,
Mr. Fleming, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
yes, ma'am.
Did you understand you're charged with the offense of obstruction or retaliation as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes,
If
ma'am.
you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Fleming, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yeah.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at $1,000 and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No motions, Your Honor.
Outside the agreement, the state is recommending that your term of supervision be for 3 years. There be a TAP evaluation, community service restitution hours, no contact with 1818 Martin Luther King Drive, no contact with Kiana Bernardo or Bernard Drive, anger and hostility management course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offer states one in attachment.
No objection, Your Honor.
All right, state you may be excused. Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding the guilty as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor, and
It-
we were gonna ask the court, he's not working currently because he's been in custody for the past, what, 2 months?
Since December 30th.
Since December 30th. If there was any part of the fine, they could be probated.
All right, so what was going on with you on this day?
Really what happened, I'm not sure who that lady is, I just got here and I was in the process of I was walking around looking for buying a house. I got hypoglycemia, my blood sugar started going, I started feeling crappy. And I figured if I sat at the bus stop, I can get on the bus until I see something to go in and buy to eat or drink, and then I can get out and then go buy something to eat or drink, and I was feeling really crappy. And as far as work and stuff like that, I don't have my state ID
No,
or
no. I'm trying to get back to why did this happen? Because
why did I don't know. I had low blood sugar and I was feeling really crappy. And in my whole life, I just remember like 12 to 18 days I've been here. I just had the cops constantly stop me and ask for my name, my social security number, my birthday, like that. And the same officer that arrested me that evening stopped me that morning at church and just got all of my information. That's why I was like, no, I'm not telling you information because I just gave it to you this morning and you guys keep following me around and harassing me. So, and I'm just trying to buy a house and move down here and married to my fiance. And it's just annoying and I'm having low blood sugar issues already on top of that. So I did.
I don't understand how you go to, I'm looking for a house and then you end up at the bus stop.
I was out walking around looking for a house to buy because that's why I was wearing it. It felt good out, wasn't chilly or nothing like that. And I was out walking around looking for a house to buy.
Sorry, what did you say?
I said it felt good outside and it wasn't really chilly or nothing like that. That's why I was just wearing a jacket and all. It was like December 30th, like I said. And I was out walking around because I don't know San Antonio that well, Command Dallas, but she's from here. And then so I was just walking around looking, for a place to live that looked nice. And then so like I said, I don't know the area. I just started feeling really crappy as my low blood sugar hit me. And then I just seen a bus stop sitting right there and well, I can't keep walking because I feel crappy because of low blood sugar. So I just sat there and then all of a sudden 3 police SUVs and a police van showed up and then I just ended up here.
And whose house were you staying?
My fiance's. I don't know the exact address. That's no on Nagalita Street. I don't know the area that well, but stay over there at their uncle's until we get a place.
Yeah, he didn't know the complainant in this particular case, who had called about, suspicious person.
And what are the tattoos on the knuckles about?
It literally just says self-made.
Wait a minute, do that again, I'm sorry. That says self-made, am I?
Russian.
Oh, okay. Do you speak Russian?
Vikky, thought it was liberal.
No, I mean, that's either yes or no. You do?
But
You go to school for that? How do you speak Russian?
I do a lot of things, and then lineage and stuff like that. And then I did I got a bunch of financial certifications and different stuff like that. And so I did a lot of business and stuff like that.
Did you go to school for Russian or what?
Business deals, things like that.
All right, business deals.
You could Google Fleming stock, current value of Fleming stock, and it says something pop up. Or like if you called it number on there for like, I don't know, I got money in every bank in the city. I just can't get to it in here. Like you Google Fleming Frost instead of Fleming. Like,
So it's your site saying if I Google Fleming Frost?
yeah, like Frost Bank or like Fleming AI or Fleming Commercial, Stonehenge Fleming, or Commercial Bank of Fleming or Fleming Financial Services or pretty much Fleming anything. Current value of Fleming stock, Fleming Island, Fleming yachts, Fleming jets. Like I really work hard. I literally take stuff and cybersecurity stuff, all kind of stuff like that.
So the commercial bank of Fleming, is that something
Yeah,
you own?
yeah, I work hard. I just literally need a state ID and social security card and 3 pieces of mail. And when I do that, like you call 1-800-432-1000 account.
Wait, what's the number again?
1-800-432-1000, it's Bank of America. If you put my social security number in there, they're gonna want you to open an account. And whenever I get my ID and stuff like that, when I walk in there and I'm gonna, whatever probation costs, I'm just gonna pay it off all at once and I'm gonna buy a house. That's why I said I do very well. I'm just gonna walk around and whatever looks nice, I'm just gonna buy it. I don't have to think.
So you own, so the bank,
Fleming Zillow, you could Google Fleming Zillow.
so I'm just trying to make sure I follow your story. So the bank you own is the bank, commercial bank of Fleming?
Yeah, and Stonehenge Fleming's another one, Fleming Steakhouse in this town, I own a bunch of stuff.
All right, and the Fleming restaurant, that's you?
Yeah, Fleming.
And is it Fleming Frost Bank or?
No, like, instead of like, okay, so the reason why is so like April 19th, 2023, like when AI got really big, you Google Fleming AI to combat its private sector, it will tell you the current value. I signed a commercial entity contract providing 230 banks with liquidity pools. So like that to like, I did it. So pretty much any financial institution you can Google my name first and it'll pop up or like, I do a lot of stuff. I have Fleming Financial Services. You can type my last name in the app store on your phone, and there'll be a bunch of apps pop up, like Fleming Steakhouse will be one of the apps. A bunch of stuff I do. I literally work really hard, and I do everything I can not to get in trouble. I just literally need a state ID and social security card, and I literally
All right, so,
help the city law.
Mr. DeLeon,
Yes,
are you aware of your client's ownership of banks?
I'm not. I'm going off the information he's telling me.
Yeah, I literally don't have no way to get it. I need help. Like like you call the bank right now, Bank of America. Like, and you put my social when they answer, because if you put my social in, they'll tell you you want an authenticated account. When I talk to her, she'll just say, I need a state ID, a social security card, and 3 pieces of mail. And I walk in there and and then that 93940230809, that number's attached to it, but that got turned off, and then the on swipe .7.
Let me ask you this. So do you understand what you're charged with today?
Yeah,
All right, what are you charged with today?
obstruction justice or obstruction/retaliatory.
All right, so you understand what's going on? And you understand what your attorney does?
Yeah,
Okay. All right. Have you ever received any type of mental health diagnosis or no? In the past?
you guys think I'm lying?
Hmm?
You think I'm lying about?
No, what I will tell you is anybody who comes before me, I don't know them, right?
Right.
Because if I knew them, I wouldn't be hearing the case.
Right.
So this is just me learning more about you because I'm going to ask you if you have any children. So let's start there then. Do you have any children?
I want to be a dad very much and husband. I'm supposed to be getting married on the 7th. And I just kind of disappeared away from the person on December 30th.
So do you have any children currently?
No,
All right. Have you ever used any type of drugs in the past?
in the past, yes.
All right, and what would that be?
I've used weed, and meth in the past. Meth, it's been years, weed, sometime last year, probably October, November, is the last time I smoked any weed.
And have you ever had any type of mental health diagnosis or?
I got Asperger's syndrome, but it's just a communication disorder. It's a form of
Oh, no,
autism. That's
I
it.
understand about that. Well, have you ever been had to take medication for anything for mental health?
I take like stuff to help me sleep, and then like I've taken stuff for like anxiety before. Other than that,
All right, do you have any family here other than the person you say you're going to marry?
on the little bit of family I have left is like in this little bit town called Chapin, Missouri.
All right. Anything else, Mr. Delio?
Nothing, Judge.
Probation, what do you recommend to help Mr. Fleming?
I think, I would recommend putting a mental health evaluation on their judge, a TAP evaluation. I don't know the facts of the case, but
Yes.
and on the plea agreement, anger management, hostility management board.
Okay. All right. This is what the court is going to do. The court is going to sentence you to 3 years deferred adjudication. There's $1,000 fine that will be probated. Regular reporting by Zoom or in person, regular UAs, the MIG TAP evaluation. I'll have that done out of custody. If you miss any of these appointments, you're going to be in custody. Do you understand?
Yeah, could you just make sure I get the addresses and stuff like that, because
They'll make sure they have that.
yeah.
We'll get your copy.
There's to be 120 hours of community service restitution. I'm going to order the anger and hostility management course. Once he completes that, the community service hours will be deemed satisfied. Proof of employment within 30 days. There's been no employment as a home health care provider or with minors. There's to be no residency with minors. There's to be no contact with 1818 Martin Luther King Drive. And there's to be no contact with Kyana, Kyana, Varnado, Varnador. And there's to be field visits 1 time per month until further notice. Probation, is there anything else? Is there anything else you need from the court? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. So probation will give you the information you need in order for you to get your identification and everything, okay? All right, if there's something else that you need help with, just let the court know and we'll see what we can do, okay?
Just at least a state ID, a social security card, and then how to get to the SA.
Well, I will tell you, they will give you the information, but you're gonna have to do it yourself. Like, for example, they're not gonna walk with you to get your license, but they'll give you the information. And they may be able to have some nonprofits that can help you more with that, okay?
Yeah, if I can get someone to just like help in that kind of sense until like I can get into it, that would be great.
Okay.
That would be
We're
great.
gonna work with you.
All right, thank you.
All right, let's have a seat.
No problem. And was he having an issue?
Yes.
Mr. Murmea, come down. How are you doing? All right, so look, when you brought over, you can't be causing problems. You understand? How old are you?
I was an older man trying to get into an aggressive speaking of there and all this other things.
Here's the thing, that's why the buzzer is there, but you can't be getting into altercations
I
with.
didn't find nobody.
Hmm?
I didn't find nobody.
What?
I didn't find nobody in.
No, here's the thing, you were brought over. I want you to listen to me and hear me clearly. You were brought over. There were some issues that developed. That's why you were sent back. So what I am telling you is you cannot be doing that, because if you get into a fight at the jail, or if something else is going on where you're being disruptive, if you have a jury trial, and if you were to be found guilty at jury trial, all of the write-ups you get at the jail, that's something that can be used in your punishment case. You understand? So don't do that anymore. You understand? Now, your attorney cannot be here today. And the reason why your attorney can't be here is because your attorney is currently in a jury trial. So we're going to recall your case.
You know, for what day?
I'm going to get you a date right now. Ms. Ferguson? Let's recall this for next week. What date? And it's Murmea.
You can do the 9th.
All right, so we're going to bring you back on the 9th. If your client, yes, if your attorney's jury trial is not completed by then, we may need to reset you, okay?
Sure.
All right, thank you. Do you have any questions? All right, thank you. Yes.
All right, Judge, we were gonna ask for a reset for Mr. Cervantes. We've been negotiating about a plea offer. We're close. Mr. Cervantes still wants to have a discussion with his family about the plea offer. I think we're close, Judge, but we need to verify one little thing with him, so.
All right, Mr. Cervantes, you're up for jury trial tomorrow, so you need to confer with whomever you want to confer with before tomorrow. All right.
Okay. So he would have to contact his family overnight in case he wants to take a plea or something.
How do I get up, go around talking to them?
That's
it. However you talk to people over there. You make phone calls to your family?
Okay.
One tonight. Okay. Thank you, Judge.
Thank you.
Judge, with Mr. Rivas, he was taken into custody this afternoon because they believed he had a warrant out of California. We confirmed it is not him out of California.
Oh my gosh, well, good for you.
He's dealt with this situation in the past where Homeland Security has talked to him and said, hey,
That's like
we
a
think
life.
you're the bad guy, and they confirmed it's not him, so.
That's a Lifetime movie in the making.
It sure is, Judge. This is our first setting on
Hey,
Mr.
you know what?
Rivas.
Because it wasn't me, the Juan Rivas story. You know, they always have weird titles. Well, I'm glad that worked out for you. All right, so first setting.
This is our very first setting, Judge. I have tons of discovery to review. So we're asking for a reset at this point.
All right, Ms. Ferguson, if I can get a 45-day reset. And are there CPS case records? We think?
Are there?
Yes, Your Honor, there are CPS records. We do have them.
And is there any cell phone information?
Not that I'm aware of at this time, Your Honor.
All right. All right, we'll have a discovery on July 17th. Once you sign the reset form, you're excused.
And lastly, Judge, with Mr. Rivas, eventually he is on a full GPS monitor. How would the court like to, we would like for him to be able to work. How would the court want us
Do you
to?
have any objection to his working?
I apologize. He's on full house arrest
He's on
GPS
full
right now.
GPS. Yes.
Upon approval of a verified job, state, I need to speak with the complainant's family, but no immediate.
All right, so if you have employment and you provide proof of employment with your work schedule, then I will approve it.
I'm gonna have to find a job. They kind of
Okay.
let me go, so.
All right,
Yeah.
just whenever you have one.
We'll figure that out.
All right, thanks.
All right, Judge.
All right, the court is calling 2024 CR 009473 State versus Millard Cummings. Mr. Cummings, if you'll come down. Could I have parties announced for the record? State?
Ashley Jones.
Raymond Martinez for Mr. Cummings.
And are you Mr. Cummings? All right. I have two witnesses on the Zoom. If you both could unmute, please, and raise your right hand for me. I'm just going to go ahead and swear each of you in. And the first person I'm going to swear in is C.S.O. Parker. Do you solemnly swear and affirm that any testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. And then the next person is Robert Cooney. Could you raise your right hand for me, please? Do you solemnly swear and affirm that any testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. So defense counsel is asking that the rule be invoked. So what I'm going to do is I'm going to put you in the waiting room. While you're in the waiting room, you're not allowed to view anything in regards to this case. Does everyone understand?
Yes, Your Honor.
All right, so I'll put you in a waiting room. I'm sorry. Yes,
I do think we're gonna call Mr. Cooney first.
all right. All right, before we call Mr. Cooney, Mr. Cummings, did you have a chance to review the motion to enter adjudication of guilt and revoke community supervision with your attorney? And did you understand it? All right, you've had a chance to review that with your attorney? Mr. Cummings, have you had a chance to review?
I'm doing it right now.
Okay. All right, have you had a chance to review that with your attorney?
Yes.
Are you saying Millard Darrell Cummings, who was placed on deferred adjudication in 2024 CR 009473 for the offense of assault, family, household, impeding breath or circulation on February 4th, 2025 for a period of 2 years? Is that you?
Yes.
All right. State, which violations are you proceeding on?
We are proceeding on all of them, Your Honor. Would you like me to read them all out?
Mr. Cummings, are you aware of all of the violations?
Sorry,
the motion-
before he goes forward, was it reduced to a misdemeanor or not?
Yes, Your Honor.
Yes. And so what ended up happening, it was reduced to a misdemeanor. And the last time we were here, the state did an oral amendment to the deferred adjudication to proceed on an assault causing bodily injury family. Is that correct?
Yes, Your Honor.
And that was my mistake. All right. So you are the person who's placed on deferred adjudication for assault causing bodily injury or family. Is that you?
Yes.
And you were placed on deferred adjudication for a period of 2 years on February 4th, 2025. Is that correct?
Yes.
All right. And then with violations, state, you said you're proceeding on all of the violations?
And yes, Your Honor, I did misspeak. We are not going to proceed on violation condition number 26. That would be proceeding on all of the others.
All right. So with regards to violation of condition number 2, how do you plead to that, true or not true?
Not true.
To violation of condition number 12, how do you plead to that, true or not true?
Not true.
To violation of condition number 21, how do you plead, true or not true?
Not true.
And to violation of condition number 22, how do you plead, true or not true?
Not true.
All right, state, oh, I'm sorry, and to violation of condition number 23, how do you plead, true or not true?
Not true.
All right, state, you may proceed.
Thank you. State with Robert Cooney.
All right, Mr. Cooney, can you raise your right hand for me, please? Do you I'm sorry, you've already been sworn in. State your name for the record.
Robert Cooney.
All right, state, you may proceed.
Thank you, Your Honor. Mr. Cooney, can you hear me okay?
Yes.
Okay, and can you please let the court know where you are employed?
Academy, Sports and Outdoors.
And do you know the address of that academy?
To be honest with you, off the top of my head, I do not know it off the top of my head.
That's okay. Is it located in San Antonio, Texas?
Yes, right off of Perrin Vital.
And so that would still be Bear County?
Yeah.
All right, and at that academy, what position do you hold?
I'm a firearms associate.
And what does that mean?
I handle and sell firearms.
And to sell firearms, do you have to run a background check?
Yes.
Okay, and would you run a background check without somebody wanting to buy a firearm?
No. They would have to come to us and tell us specifically that they want to buy a firearm.
And speaking to that, on April 10th of 2025, did an individual come to you wanting to buy a firearm?
Yes.
What was that individual's name?
Mr. Cummings. Off the top of my head, I can't remember the first name.
And do you see him in the courtroom today?
Yes.
Okay, and can you point him out by an article of his clothing?
Orange jumpsuit.
The record could reflect that the witness has identified the defendant.
All right, and can you tell us about the first interaction you had with Mr. Cummings?
The first interaction was actually um probably about 2 or 3 weeks beforehand. It was not even on that the day of April 10th. Um,
Where was this interaction? Where did this interaction occur?
at the store at the academy. He had come in. I don't remember what time of day it was. Um, but he had come in. Um, saying that he wanted to buy a firearm. I proceeded to ask the usual questions: what firearm, if he had a Texas ID, um, what the gun would be used for, if it's going to be for home defense or concealed carry or anything like that. He had already had a gun picked out. Oh, I'm sorry.
Okay, and that's what I was, did he answer those questions?
Uh, he answered it kind of, I would say, half answered them. Um, he was not very straightforward for the most part, other than already knew exactly what firearm he wanted. That was the one thing that he was pretty straightforward about, was he already had a firearm in mind that he wanted to purchase.
Do you recall that type of firearm that he wanted to purchase?
Yeah, it was a Ruger LCP 380.
And for those of us not familiar with guns, what type of gun is that?
It's a pistol.
Okay, how many rounds does it hold?
About six, I want to say 6 or 7.
And on this occasion, did he present an ID to you?
He did have a format of ID, just not a ID that I was familiar with myself.
What type of format of ID did he have?
It was some type of county ID, uh, Bear County Correctional or something of that matter. Like I said, it was not a ID that I was familiar with myself.
And after presenting you that ID, what next steps did you take?
Well, since I wasn't familiar with the ID, I did try asking him what kind of ID it was. I noticed that it said county correctional. I'm not from Texas myself. I just got here a few months ago, so I was questioning it. I asked him if it was for, if he was an employee, like a correctional facility employee or anything like that. He didn't really answer that question. Um, at that point, I started calling my manager out. He came out. He himself was not familiar with the ID either. At that point, he kind of took over, started asking him, pretty much the same questions that I was. What kind of ID is it? Um, stuff along that line.
And ultimately, on that day, did he purchase a firearm?
No.
And when he left, what would you say his demeanor was?
Um, I would say definitely seemed, a little irritated, a little confused. Um, he had, at some point in the interaction, he had told us that he had been released from jail. Um, he, yeah, he said he had been released from jail. Um, didn't really give us a time frame, but it had been within a few months from what it seemed like, because he said that was the only ID he had at the time. And like I said, when he was leaving, he was pretty confused, pretty irritated, because we told him that he wouldn't be able to sell a gun or be able to purchase a gun. So he was pretty irritated, pretty confused on why we wanted to sell him one.
And moving on to the next interaction you had with him, on what date was that?
That would be the April 10th,
Of what year?
2025.
And would this still be at the Academy on Parent Vital?
Yes.
And during that interaction on April 10th, what was that interaction like?
He came in, again, he was pretty straightforward about which firearm he wanted to buy. Um, according to Academy's, I guess you would say, their regulations, when we have a customer come in that, we're unsure about, they do want us to proceed with the interaction as we would with any other customer. So he came in, he wanted to purchase, he knew what he wanted. At that time, I am pretty sure that he presented a change of address form from the DPS, and I proceeded as normal, starting off with, showing him the firearm and starting to get his stuff into the computer system.
And what firearm did he want to purchase this time?
It was still the same firearm.
Okay, and um, what questions were asked of him on April 10th regarding his purchase of that firearm?
Pretty much the same things, his ID, what ID he had, which again would have been a change of address form from DPS. Um, and pretty much the same thing, what is this firearm going to be used for, anything like that, which again he didn't really clarify. Um, but this interaction was a lot shorter, because again he came in, he had the correct identification, but he still had kind of the same demeanor that he had the first time, just kind of, you know, I wouldn't say odd, but just off. It wasn't like the usual interaction with the customer.
And you had mentioned that you showed him the firearm. Can you tell us
Mhm.
about that?
So, clearing the weapon, taking it out of the box, clearing the weapon, making sure it's unloaded, um, handing it over so that way he can, physically and visually check the firearm. He hands it back. Uh, I put it back in the box. We go over the serial number, confirming that everything on it is matching on the firearm and the box. And then, like I said, getting him put into the computer system.
And after you get him put into the computer system, what next steps or how did this interaction go after that?
So once I enter his basic info into the system, at that point, that is when he is handed the iPad that we use, and he himself begins the actual 4473 background check.
And after he completes everything in the iPad, I'm assuming he hands it back to you. How long does it take to get that background check back?
It can be hit or miss, but generally it is within 5 to 10 minutes. On for his, I do not remember particularly how long it would have. I don't remember how long it took to get his back.
Can you tell me how the interaction with him on April 10th ended?
I do not remember exactly how it ended. I cannot recall if it came back um denied while I was on shift or if it came back later that day. So I wouldn't really be able to tell you other than his um I guess you say his mannerisms still just kind of seemed off to me.
And what seemed off?
Just the way he talked, the way he moved around was kind of jittery. Um, I've been selling guns for about 5 years now. So there's just little things like that that, you know, you kind of pick up with somebody that when they're buying a gun.
And to your knowledge, was he successful in actually purchasing the firearm?
He was not.
But again, to your knowledge, since you were the employee handling this, did he ask you to buy a weapon?
He did.
Did he complete paperwork to buy that weapon?
Yes.
And did he handle the weapon that he wanted to buy?
Yes.
I'll pass the witness, Your Honor.
All right, defense.
I'm sorry, sir, could you pronounce your name again for me?
Cooney, Robert Cooney.
I'm sorry, the B's throwing me off. So, Mr. Cooney, is there a way that a person can get a background check other than going through the process you just described?
No, there's not.
So if a person wants to know whether they're gonna be approved, they gotta go through all the steps you just outlined.
Yes.
Because you don't let them go to the final step to do that application process until you've selected a firearm and basically done all the precursors for purchasing a gun, right?
Yep.
But no money ever changed hands in this situation, correct?
There was no money. No.
And matter of fact, you don't even ring them up in the register until the background check is done, correct?
Yep.
So if a person wanted to get an answer to the question whether they qualified to get a gun or not, they would follow the same procedure you just outlined.
Yes.
And if the person comes back, whether he's approved or not approved, at that point, he can decide to complete the transaction or not complete the transaction.
If he is not approved for the firearms, then he has no choice in the matter. He would not be able to, you know, purchase if he did not get approved.
Understood, but even if he was approved, he's not obligated to buy anything at that point.
That's correct. He would not be obligated to.
And in fact, you would have taken no deposit or a card or cash or anything at that point.
Yep.
So you're assuming he's attempting to buy the gun because he wants to go through this process, when in fact it could be that he just wants to see whether he's gonna get approved or not.
Yeah.
No, that'll be overruled. I understand the objection.
That's all I have, Judge.
All right, any further questions?
No further questions from the state, Your Honor.
All right, is this witness excused?
I think so.
Excuse for the state, Your Honor.
All right, thank you so much for coming in. You're excused.
Thank you.
All right, and is your next witness, CSO Parker?
It is, Your Honor.
All right, CSO Parker, we're ready for you.
Yes, ma'am.
All right, you've already been sworn in. If you'll just state your name for the record, please.
CSO Aramis Parker.
All right, you may proceed.
Hello, Ms. Parker.
Hi.
Thank you for coming in today. I did want to talk to you about one of your probationees, Mr. Millard Cummings.
Yes, ma'am.
Do you see him in the courtroom today?
Yes, ma'am.
And can you point him out by an article of clothing?
He's wearing orange, top and bottom.
If the record reflects, Ms. Parker has identified the defendant. When did he come to be on your, when did you come to be his probation officer?
He was assigned to probation on February the 5th. Excuse me, February the 4th of 2025. And he was assigned to me on that date.
When was your first meeting with Mr. Cummings?
It was on March 14th of 2025.
And on that meeting, did you go over his conditions with him?
Yes, ma'am.
Okay, and would you go over all of his conditions?
Yes, ma'am. All of them.
Okay, and would that include drug testing and the FIT course, the TAP evaluation, and calling into the UA hotline to see if he is required to submit a drug test?
Yes, ma'am. We went over all his conditions, including what you just stated.
And so going to February 14th of, I apologize, 2025, on that date or around that date, had the defendant completed his batterer's intervention and prevention program?
Do you mean March 14th?
Yes.
Okay. No, March 14th was our first visit. So on our first visit is when we went over everything that was that he signed and agreed to with his conditions. March 14th, he was given his copy of his conditions again and handouts of the classes and the parenting. So he had not completed anything by that date of March 14th.
And to this date, presently, has the defendant completed his batterer's intervention and prevention program course?
No, ma'am, not the one that he was ordered to complete. He completed a bib class that was not approved. He took a class on his own online, but that's not one of the classes that is court approved through 187. So to date, no, ma'am, he has not completed the required bib course.
And what's the difference between the online course he took and the court approved fit course?
Yes, ma'am. The one that I believe he took online, the one that he emailed me, is 20 hours. I want to say I have to look it up, but I want to say it was like a 20-hour course. I'm not too sure. Please don't quote me that. But the one that he is to take is in person and it's 20 sessions. So it usually takes maybe about 4 to 5 months to complete. But I do want to also mention he did go and register at one of the locations that was on that paper, but he refused to fill out the required documents there. So he was not signed up for that. And he just stated he did what was convenient for him. When I did speak to him in April, he just told me he did what was convenient.
And
So
I'm so sorry to interrupt.
yes, ma'am.
But what you're speaking about is the BIP course?
Yes, ma'am. I'm speaking about BIP. BIP only. Yes, ma'am. Mhm.
All right, thank you.
Yes, ma'am.
Okay, so moving on to the TAP evaluation.
Yes,
When
ma'am.
is he scheduled to take that?
The tab was for April the 9th of 2025.
And did he attend his TAP evaluation?
No, ma'am, he did not.
And have you spoken to him since that date?
Since April the 9th? Yes, ma'am. He had an office visit on April the 14th. The last time sorry, go ahead.
Did he provide a reason for not attending the TAP evaluation?
So I actually scheduled him to come see me that same day after his tap. When I asked him about on the 14th, he didn't give a valid reason. He didn't say why he missed it or anything. He did not give me a reason on why he missed it.
And so talking about the UA line, can you tell us what that is?
It's what it is a line. He will be, it's called Century, the program. He's put into the system. He's given instructions on that he has to call this number every day, and it tells him the date and time that he has to call. And then when he calls, it will let him know if he needs to go take a drug test that day. So he has to call that every day.
And did he call every day that he was required to?
He did not call. No, ma'am, he did not call every day.
And did he call on March 17th of 2025?
Can I look at my notes?
Yes.
Okay. March 17th of 2025, he did not call.
On March 21st of 2025, did he call?
He did not call. March 21st, no, ma'am, he did not call.
On March 24th of 2025, did he call?
He did not call.
On March 28th of 2025, did he call?
He did not call.
On March 31st of 2025, did he call?
March 31st?
Yes.
No, ma'am, he did not call.
On April 4th of 2025, did he call?
No, ma'am, he did not call.
On April 7th, 2025, did he call?
No, ma'am.
On April 11th, 2025, did he call?
No, ma'am.
And on April 14th, 2025, did he call?
No, ma'am.
What about April 16th of 2025?
No, ma'am.
And was he ever required to submit to drug testing? Or to submit a drug test?
Sorry. So he is, so because he's on this UA line, it tells him when to drug test. So he wasn't, I didn't send him for a drug test because he's on this line to call. So by the time I saw him on April the 14th, once we discussed everything, I did not send him for a drug test, no, ma'am. Because he's on this UA line. So usually when they're on the UA line, they'll let them know when to take the drug test.
On March 19th, did it let him know to go take a drug test?
Yes, ma'am, it did. Sorry, let me confirm that. I'm sorry, March. My paper is a little small. Yes, ma'am. It instructed him on March the 19th to go take a drug test.
Did the defendant go and take a drug test on that date?
No, ma'am, he did not.
And on what date did you, I apologize, let me reach that. How would you describe Mr. Cummings as a probationee?
Mr. Cummings, our first visit, very polite. He was receptive to the information. He appeared to understand everything I gave him. He did have some, it appeared that he was upset about something that happened prior to probation. He kept trying to talk to me about something with Medicare and some rights being taken away. So he just appeared to be really angry about something that's happened prior probation. So I had to rear him a lot to just focus on what's at hand, and I couldn't control what happened before. So he just appeared to have a lot of anger in him. It wasn't directly to me. I never felt, it was ever directed towards me. I just think it's just something in his past that was bothering him. But we only got to meet three times, April, or 2 times, excuse me, only got to meet. So we really haven't built a rapport, but in the couple of times I met him, he was always respectful. He was never disrespectful. He's just appears to have, trouble following the directives that was given to him.
Would he ever, how would you describe his punctuality?
He was always late, at least an hour or two late to his appointments. So he wasn't punctual for his appointments.
And for these violations that we've gone over today, would those have occurred here in Bexar County, Texas?
Yes, his violations, yes, ma'am, in Bexar County.
At this time, Your Honor, I will pass the witness.
All right, defense.
So Ms. Parker, first question is how do you know whether or not he called into the UA line?
There's a report that is ran on Century. You can run a report and you can put the dates. And so from the date that we put him in and from current date, if we would like, it'll say call missed. And if it says yes, that means that he did not call in. So the only ones that are going to say no is the ones that are on the weekend because he's not required to. So the report that's provided on Century lets you know. And if he does call in, it will tell you exactly the time that he called in. It'll give you a time as well.
Does he have any instances where he did call in? That's my question.
He did not. He did not call in at all. If I can say that on one of my violation reports, I put that he did call in, but I was mistaken because that was a weekend and I read the report wrong. So as far as ever calling in, he did not. And even when in our office visit in April, I asked him why he hadn't called in and he just said he had a lot going on.
So you said that you asked him to report on the same day that he had his TAP evaluation, correct?
Yes, sir. I believe on that same day, he had a original appointment. And I might be, if I can look at my notes real quick, I believe he had an appointment on that day, just his regular report date. I believe it was that same day, but I can double check that real quick if you would like. Is that fine? Yeah.
Sure.
Okay. Let me look real quick. No, it was on April the 11th. It wasn't the same day. His TAP appointment was April 9th, and then he was to come report to me on April the 11th.
Okay, so the violation that he missed his TAP on the 11th is actually incorrect.
It's not the TAP. He missed his TAP on April the 9th.
Okay, well, that's what I
He
mean.
did miss his TAP on April the 9th. He didn't show to that appointment at 8 a.m. His TAP.
So he did not have a TAP on the 11th.
No, ma'am. No, sir. Excuse me. He did not have a TAP on the 11th.
Okay, but he did show up to his reported meeting on the 11th.
He showed up 2 hours late. Yes, sir. And then I was actually leaving for the day and he was instructed to come back April the 14th, in which he did.
Okay. So and he completed a BIP class, but not the one that he was supposed to take.
Yes,
correct?
sir. Yes, sir. He completed an online course.
Has he also completed a parenting class?
He did complete the parenting class after the first time he completed it. It was an incorrect class. And then when I told him that that wasn't what was approved, he did go back and do the correct class. Yes, sir.
So we have a probationer that seems to be able to comply with certain conditions, but is missing on some others.
Yes, sir.
Did you notice that maybe there was a possibility that there was some things that he was processing and understanding and other things that he wasn't?
No, sir, he understood everything the first visit. He was provided with all the handouts, which specifically told him exactly where he needed to go and call to take the classes. We also communicated via email, so he had it in his email as well. So I don't think there was any confusion on if, if he can complete this or not.
And where is he supposed to go to submit to the drug test?
He has two options. He could submit here at my office in Crestway, or he can go downtown to their main location. So he had two locations he can submit.
And it's your belief that he had that information?
Yes, sir. He had that information. That he's given a handout that has the addresses and the times.
And then on calling in, do you have records of him actually making some calls, just not all at once?
No calls at all.
Okay.
No calls. The record shows no calls at all.
Now, did you inform him that he had a motion to revoke that was filed against him?
I do inform them. That is our protocol. Yes, sir.
Are you aware that he tried to surrender himself to take care of that warrant in the courthouse?
I was not aware.
He hasn't been in contact with you since then?
He has not been in contact with me. No. When he was informed of it, he sent an email. He didn't acknowledge the email that he had a warrant. He just responded with he made a payment and he sent his class again. And then he had some other things in the email, but he never I hadn't had a face-to-face visit with him since I told him.
So, Ms. Parker, what is the impression or feeling that you have about Mr. Cummings as a probationer when you see him actively trying to submit information to you, actually complying with a condition or two, but then totally missing certain others, but then submitting himself to the court when he knows he's got a motion to revoke? There just seems to be a contradiction there. What do you think about that?
I believe that Mr. Cummings, it's some thinking errors there. I do believe, I don't know, I can't really answer why he's not following the directives given to him. But I believe he has the potential to follow him. I just don't understand why he didn't. So I don't really know how to answer that question, but it seems as though he did make an effort. But why he chose to go a different route, I don't know. He just told me what he did, what was convenient for him. He did question a lot of things as far as like, why do I have to do this? Why do I have to do that? Which we answered that, but I do believe he has the potential to follow. It's just he just chose not to. But I do commend him for, turning himself in and taking care of what he needed to do. I do commend him for that. And to say that he didn't report, he never just not reported. It was just always a late route. So
All right.
I do believe he made the effort, but
No further questions from the state, Your Honor.
All right, I have one question, if there's no
ma'am.
objection.
Yes,
Yes,
ma'am.
Judge, I asked the one I forgot. And then,
All right, yes.
Uh,
Maybe your question is my question.
can you let the court know, Ms. Parker, if he's made any payments towards his probation?
I can check for you right now, sir. He made one payment on April the 11th for $500.
All right, that's not the question I have. Any objections to my asking the question?
No, Judge.
Not from the state, Your
All
Honor.
right, so I have a question about his conditions of probation.
Yes,
I'm
Judge.
usually very technical. So I understand, I see that the state is saying that he attempted to purchase a handgun as one of his violations of probation. So the question I have is, part of his conditions is that he's not to attempt to purchase a handgun? Does anyone know?
I think he can't possess one is what I've always thought the condition was.
One second, Judge. I am going to pull that up right now. Okay, condition 12 just says you shall not purchase, receive, possess, or transport any weapon, including but not limited to a club, explosive weapon, firearm, ammunition, illegal knife, martial arts weapon, brass knuckles, or chemical dispensing device during your term of community supervision.
So there's nothing there that says you're not allowed to attempt.
You shall not purchase.
All right,
That's the wording. You shall not purchase.
okay. All right, is there any other questions?
Not from the state, Your Honor.
Any other questions? All right, is this witness excused?
Yes, Your Honor.
All right, you can be excused. Officer Parker, you can stay on to see what the court decision is going to be.
Yes, ma'am.
Any other witnesses?
Not from the state, Your Honor.
Defense, any witnesses?
Mr. Cummings.
All right, Mr. Cummings, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Marlon Doral Cummings.
All right, you may proceed.
So, Mr. Cummings, you are aware of and you understand the fact that you cannot possess weapons on probation, is that right?
Yes.
Did you in fact surrender some weapons when you got placed on probation?
Yes.
And how many weapons did you have that you got rid of?
Well, 4.
And how did you dispose of those?
Just took it to the marshal.
So you sold
All of them. Yes, sir.
So you heard the gentleman from Academy testify. What was it you were trying to accomplish by that process at the Academy?
I had showed him my Bear County jail card just so that he could understand exactly that I just got out, and at the same time that I was trying to figure out exactly what's going on with my background. I haven't been in trouble over 15 years, and even beforehand, I had spoke to him. I told him that I had just left from the police station where I was trying to get that information, and that they had sent me to Nacalitos to see about my property, because I never knew what exactly was on in my property. At that point, they did a background check, and at that point, I got online at the DPS and through my driver license and my CHL to try to figure out exactly what's going on. At that point, then I went to okay.
And you said CHO, you in the past have had a concealed handgun license, is that right?
Yes.
And but obviously couldn't use it during your term of probation.
Exactly.
So in filling out all that paperwork, were you attempting to discern you were still disqualified? What was why was it that you did not understand what your status was?
I just wanted to just go through the process of just really just trying to understand exactly what was the holdup at the police station for my property, because they were saying that was going to take like 6 months to a year or something like that. So that's why, I was just trying to really get like up to date, because I felt like, I had property there that, I would like to see exactly what's there. They wasn't giving me that information.
Now, did you understand about the UA line having to call in and then if they say it's your day, you have to go get tested?
Yes, I was told that since I wasn't arrested for drugs, that I could just call. And at that point, if they felt that it was needed for me to take a drug test, I would take a drug test.
Okay. But you understand Ms. Parker says you're not even calling in.
Yes.
Is it that you just slipped your mind or you didn't really understand the instructions?
I was just new to like I was just new to probation and just having a whole lot going on and stuff like that, trying to place a roof over my head and stuff like that.
And I suggested to the court that in terms of saying you actually hired me to come and try to get you your bond set and all that business. Is that right?
Yes.
And then on the day that I asked you to come so we can meet the judge and talk about that, they actually, you got ahead of me and went to the satellite booking office, and that's when they took you into custody.
Yes.
Okay, so that was an idea of you walking in the wrong room at the wrong time. But you were in the courthouse for the purpose of dealing with the warrant, correct?
Yes.
Okay, so are you asking the court today to reinstate you and give you a restart on your probation so you can comply?
I'm just looking for just for some help. Me being on probation and me being a homeowner and going through the situation and having a warrant for my arrest, haven't been able to be at home. I'm just trying to keep my home because of a foreclosure like I have from going through a theft situation. Police reports have been provided already for that, but so by me, I'm just looking for help at this point.
That's what it's just.
State?
Recommended for the record, Your Honor. Mr. Cummings,
Yes,
do you recall entering your plea to this case back in February of this year?
yes,
Do you recall the judge going over all the terms of your probation with you?
yes,
Did you understand the affirmative finding that was entered to you?
yes,
You understood that that affirmative finding meant that you could not attempt to purchase a gun, weapons, anything like that?
yes,
Um, do you recall meeting with Ms. Parker, your CSO?
yes,
Did at that point, did she go over all the conditions with you as well?
yes.
You asked her any questions?
Yes.
And what were those questions related to?
She gave me all the, she gave me good answers and I understood.
So you understood all the terms of your probation?
Yes.
Okay.
Yes.
Okay. Now you mentioned that you were wanting to determine the status of the background check, is that correct?
Yes.
Do you feel like there was any other place you could go to try and get that done other than Academy?
I went to the police station and I went to the to where the other police station I have over there for not to. And I did it online. I did it online too. Before going to Academy.
So you did those three things before going to Academy?
Yes.
So what was the need to go to Academy if you really gone through two law enforcement agencies and online?
They wasn't able to give me that information.
Okay, and you felt like Academy would give you the information you needed?
Yes.
Okay. Do you feel that it was a good idea to try and purchase a gun while you're on probation?
I wasn't trying to purchase.
Did you, well, if you weren't trying to purchase it, did you handle that gun while you were there?
If you were to see the video, I told them like, I found I didn't really recall it or really touch it. So if I did touch it, I'm for sure video you can see me go, okay, right, cause I didn't really touch it.
Okay, so you never held the gun in your hand at all?
I really don't recall. I don't recall, just.
Well, let me ask you this, what you don't recall, do you recall going the first day that the Mr. Cooney testified to?
Well, the thing about that, I was trying to remember, so, I filled the form out 2 times. I thought you said it was just 1 time. I thought you said the first time I just showed him my Bear County license, and I didn't have my ID and stuff like that, which I did. Y'all gave it to me when I got.
Well, let me ask you this, you do recall going there on 2 separate occasions, is that correct?
Yes.
Okay. No further questions, I'll pass it.
Any other questions? Any other questions?
I think that was it, Judge.
All right. The court will hear argument, and before I hear argument, this is what clarification needs to be given to the court. I think it's clear that violations of conditions 2, 21, and 22 are true. Now, I'm taking in consideration, of course, the fact that with regards to the BIP, he took a different BIP, he turned that in. So I'm weighing that, but it is true that he didn't take the BIP course that was required of him. What I'm saying is not true is number 23, the failure to attend the TAP evaluation, because the witness testified that the date for that is not the correct date. Number 26, that was waived by the state defense. I forgot to ask you, with regard to that, do you have any objections to the state's waiver of number 26?
I do not, Judge.
All right, so this is what the court's issue is, the one that's the quandary. The attempt to purchase of a weapon. Based upon the evidence that I've heard, he attempted to purchase a weapon. We can say he was in there to see, oh, let me see if I would qualify to get a weapon. But I think regardless of whether he was going in, whatever his purpose was, it was still an attempt at purchase. So the question becomes whether or not attempting to purchase a weapon is a violation of his probation. And to determine that, there needs to be an express condition that says he's not allowed to attempt to purchase a weapon. Now, if it were to be a new number one, attempt to purchase a weapon or something of that nature, then it would be an easy decision for the court. But it's not listed as a new number one. It's just listed that he attempted to purchase a weapon. So if you all can hone in, and maybe the witness has some more information on whether or not it expressly states in his conditions of probation that he is not allowed to attempt to purchase a weapon. That's what I need to know. I believe the witness testified that that's not a part of his conditions of probation. What she read to the court is he's not to possess a weapon. She named certain weapons he can't possess, the brass knuckles, the firearm, but I didn't hear anything about an attempt to purchase.
And Your Honor,
And I'll hear that.
I'll speak to that.
Yes.
So the condition specifically states the defendant is not allowed to purchase a handgun. To complete that purchase, he would have to pass the background check, which he can't do because he's on probation. And so I believe that is why it's listed as attempt to purchase. He would never legally be allowed to purchase the weapon, but they do prevent him from doing that.
Some places they do let people purchase a weapon even though they're not supposed to. I understand what the state is saying, but conditions of probation need to reflect that, because everybody's going on what the terms that are in the conditions of probation. Does he know that he's not supposed to attempt to purchase a weapon? Yes, but we're dealing with what the conditions are in his conditions of probation, because that's a contract.
And Your Honor, if you would like, I can ask the witness some follow-up questions. To see if she
Sure.
has anything.
I mean, because I think that's one major point for all of this. And I think that's why everybody has red flags, because there's an attempt here to purchase a weapon. But yes, if you would like any objections to reopening for more information from the officer.
Oh, Your Honor.
All right, Ms. Parker, you're still under oath?
Yes.
Yes.
Ms. Parker, were you hearing the judge's concerns just now?
I do hear her concerns, yes. It does read, you shall not purchase, receive, possess, or transport. The condition does not say you should not attempt. That's correct. But I also agree that because he didn't purchase, because the background check didn't go through, that's probably why, I assume that's why it wasn't purchased. But the conditions does not say he cannot attempt.
And that would be just the state's argument to that condition, Your Honor.
Judge, there's always a possibility that they said, yes, you can buy it. He said, I don't really want it. Now I know that I can. Maybe I'll do it some other day. He could have just walked away from it.
Well, I think this is a situation where maybe the conditions of probation need to be reworked to put in there that you cannot attempt to purchase or possess these other things. Because
And Your Honor, I will also speak to the violation of condition number 23. I know that Ms. Parker testified it was on April 9th, not April 11th. However, that is why we have the honor about language on there.
Yeah. Yes, I'm sorry about that. I misspoke. I said April 9th. His TAP appointment was Friday, April 11th. I misspoke on the date. I apologize. I misspoke on that date. His TAP was Friday, April 11th at 8 a.m. and he did not show on that date.
all right,
I did
there's a
misspeak.
correction for the court then.
Yes,
Uh,
ma'am.
Violation, this is what the court is finding true. The court is finding violation of condition number 2, which states that he didn't take his drug test. The court is finding that is true. Court is finding violation of condition number 21, that he did not enroll in the BIPP course as true. The court does understand that he took a different course that was not the intensive course that the BIPP is, and the court ordered the BIPP course. The court is finding violation of condition number 22, not calling the UA hotline. The court is finding that true. The court is finding violations condition number 23 true. That's the TAP evaluation. The court is finding violation of condition number 12 not true. The attempt to purchase a handgun. The court does find that he attempted to purchase a handgun, but the court is finding that that was not a violation of his conditions of probation because that was not one of the conditions of probation. The court is finding number 26, the state waived, so the court is not ruling on that. Any questions about the court's findings?
Just argument on punishment. Your Honor.
Okay. All right, and then so that the record can be clear, according to the judgment, the defendant is on deferred adjudication for assault causing bodily injury family as a Class A misdemeanor. Both parties had no objection to the state amending the defendant's motion to revoke to read that the defendant was placed on deferred adjudication for assault causing bodily injury family on February 4th, 2025 for 2 years. All right, the court will hear argument.
Yes. So given that this defendant has been on probation, he was put on probation on February 4th of 2025, pretty immediately as the court has found true on multiple violations, the defendant has not done what he was supposed to do on probation. He has instead done, as Ms. Parker stated, what's convenient for him. It was not convenient for him to do the TAP evaluation because he did not want to submit any UAs as he didn't on March 19th. And as he never called in to do the random UA hotline to see if he was required to submit to any drug testing. Additionally, he did not do the BIP and the BIP class. He did the BIP class that was most convenient for him, which is 20 hours. That's vastly different than the 4 to 5 month long in-person BIP course that is required by the court. Additionally, Your Honor, I do understand that the court did not find a violation of condition number 12 true. However, the court did find that the defendant did attempt to purchase a firearm, and that is concerning given the type of offense that this defendant is on probation for. That is a huge red flag to the state, Your Honor. I understand that the defendant is saying that he went in there to get a background check. If that's the case, he said he filled out the form twice in his testimony. So on that first visit, that could have been, his denial, but he went back a second time. And the only reason for going back a second time, Your Honor, and handling that weapon a second time and knowing exactly what kind of gun he wanted to purchase for the second time was so that he could buy that firearm. And that is a danger that is directly against the affirmative finding of family violence. And that presents himself to be a danger to this community and not only to the complainant as well. And so for that, Your Honor, given the red flags that this defendant has posed while he has been on probation for the 2 months that he was on probation before this motion to revoke probation came out, the state is asking that he be terminated and sentenced to 1 year in the Bexar County Jail.
Right, defense?
Judge, it's totally understandable why people will say there's red flags, but the real issue is what's behind all that. Is this a case where we really need to be concerned, or is it just on its face appear to be dangerous? Because we have conflicting evidence in this case. He's only been on probation 2 months, March and April. Well, 3, May, and he did the wrong BIP class, but he did a BIP class. He did the parenting class, which was the correct class. He did go to his orientation. He's reporting as he's supposed to. When he found out he had the MTR, he responded to the probation and said, "This is what I've done." And then he got with me to try to resolve the MTR. So he's not doing it perfectly. I would disagree with that. When he went the first time, he never got an answer about whether he qualified or not. They just didn't run him. They didn't run him until the second time. Then he found out he couldn't, and he didn't. And that was the end of it. And good question by counsel. Why didn't you get that information somewhere else? Because they wouldn't give it to him. He went to actually 3 other places. And the place on Navalitas, what he's talking about is actually the property room, which they don't have that information, but it is the San Antonio Police Department office that deals with property. So he wasn't that far off. So he's a little bit off in how he's handling it, but he's trying to handle it. I think we now understand Mr. Cooney's testimony about maybe there seems to be a lack of a meeting of the minds. And what we attribute that to, I'm not sure. But he's now been in jail on a Class A misdemeanor over 60 days. He hasn't complained about it. He's been to court. He's trying to handle it.
The recommendation from the probation was to put him on intensive supervision. If he wants to continue and not serve out the rest of his sentence, I would join in that recommendation. I've asked him, I think he wants to get back to his home and his personal belongings and things that he needs to be taken care of because he's about to lose them by being in jail too long.
All right, probation, what is your recommendation?
Judge, our recommendation is ISP intensive supervision. We feel, reason being we didn't go with revocation, we just feel that he needs a more structured environment as far as field visits, curfew, so more intense supervision. So our recommendation was ISP.
All right, so this is what the court's thinking is. State, I do understand your concern. However, I think everyone knows the rules at the Bexar County Jail. If I were to sentence him to 365 days at the Bexar County Jail, which is the maximum, at the jail, you receive 2 for 1, 3 for 1. He will be soon released. Defense counsel says he already has 60 days. So depending on what is happening at the Bexar County Jail, either he's going to get credit for just 60 days, or either they're going to give him credit for 120 days or 180 days. There's overcrowding at the jail. I think in this case, one, probation will probably now tighten up their conditions of probation to include do not attempt to purchase weapons. Mr. Martinez, that's one of those cases where you maybe win an appeal, but then the defense bar is upset because now things have changed. I could do one or two things, and I'm going to leave the choice up to you. I can continue you, but I'm going to put you on GPS. That's how I'm going to tighten it up for you. He will be allowed to work, but that's it. And then if he proves to the court that he's able to abide by the conditions, then the next step the court will have is the court will then allow him to still be on GPS, but there'll be a curfew. And then the next step will be tracking. Then the next step will be removal. That's your choice. You can either do that, but you're going to be on GPS if I continue you, or either I will send you to the Bexar County Jail, and I'm taking into consideration the fact that you were sort of doing your own thing. So I will sentence you to 360 days at the Bexar County Jail. So those are your two choices. You can either do 360 days at the Bexar County Jail, or either you can do GPS. And let me just tell you what I'm going to do. If you choose to continue on probation, I'm going to do GPS, and I am going to do a 30-day jail sanction. And I'm going to give you credit for the time that you've been in custody. So if you're ever sentenced or revoked on this probation, you won't have 60 days. You only have 30 days. So which do you prefer? You want to speak to your attorney?
Judge, clarification for me, GPS for the duration?
Until further notice.
He's fine with GPS.
All right. So this is what the court is going to do then. And is there any other conditions, state, that you would like?
Just see. Attempting to purchase a firearm, Your Honor.
All right.
And then, of course, just all the other remaining conditions to be kept in place.
All right. This is the court. The court would deny the motion, alter the main conditions to no attempting to buy any weapon. So that means brass knuckles. That means everything that is on their list. Do you understand? No attempting to purchase or obtain any weapon. GPS, waive fees. He's at the Bexar County Jail, so it'll be easy for them to do it there. And there's going to be a GPS until further notice. And there'll be partial GPS for employment and for any conditions of probation. So if you have to report and you're on GPS, then you can go report. If you have to take your BIP class, then you can go take your BIP class. But here's the thing, when you're on GPS and it's for work or for you to go to probation, you cannot stop at Burger King, HEB, or any of these places, even if it's on the route, because it's going to show up as a violation. Do you understand?
Yes.
All right, so partial GPS for employment, and I'm just going to say fulfillment of probation conditions. And all other conditions are still in place. Probation, is there anything else that he needs?
Does he need to retake the BIP course?
Yes. You're going to take the BPI course that the court requires you to take. You understand?
Yes.
And Your Honor, does he need to do the TAP evaluation as well? Would that be done in custody or out of custody?
TAP evaluation is usually 2 weeks. We can do the TAP evaluation out of custody. If you miss that TAP evaluation, what's going to end up happening is they're going to file a motion to revoke. Do you understand?
Yes.
Probation, is there anything else? Is there
No,
anything-
Judge. No,
Thank
Judge,
you.
that's it. Thank you.
Thank you. Is there anything else you need from the court to be successful?
No, I just wanted to say, thank you for taking the time just to, I guess.
You're welcome. Do you understand everything? So if you have a question, next time you have a question about something, ask your probation officer. And if they don't answer it, you could have came here to the 187th and said, Judge, I want to know if I can purchase a gun, or if I try to purchase a gun, what will happen? And I would have told you a motion to revoke is going to be filed and nobody should be allowing you to purchase a weapon. That's why I'm here. All right. Okay. Good luck to you. Thank you.
Thanks, Judge.